20th.
Good morning, everybody. Welcome to the Courtroom Files Live. It is a Thursday. Welcome in. Michael Groff, again, filling in for Dan Soul, who is still on hiatus until next Monday, where he will return. In the meantime, we're having lots of fun filling in here, and we'll start our day out in Michigan. Say good morning to Judge Simpson
versus Jeffrey Williams.
Cash stops for people.
Okay. This is Ron Brown.
Yeah.
Second row. I think it's going to be a waiver. Second row. It's going to be a waiver.
Okay. That's the public defender tonight to carry out the room, Your Honor, on behalf of Mr. Jeffrey Williams. I'm going to.
Okay. Oh, here he is.
Ron Brown, praying on behalf of Mr. Williams.
Oh, he's going.
You all right?
Yes, sir.
He's going to waive it.
Mr. Williams, you're going to waive your right to have a preliminary examination? Yes, sir. All right. You understand that that's a hearing where the people would have to show by probable cause that the offenses alleged were committed and that you committed them. Yes, sir. You understand you'll not have that hearing and you'll proceed to circuit court for further resolution? Yes, sir. People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on both counts. Mr. Brown.
Ron Brown, praying on behalf of Mr. Williams, waive reading, standing, request adjourned. Date, circuit court.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea as both counts. Pretrial will be set for
November 19th at 1:30 with Judge Conlon.
November 19th, 2025, 1:30, Judge Conlon.
Bond continue.
Bond in this matter will continue.
Thank you.
Thank you.
I'll come to you.
Court does call the case of the people versus Randy Harper.
Cash stops for people.
Pardon? He's coming here.
Good morning, Your Honor. Christopher Shumke, on behalf of my client who approaches.
Yeah. Morning. Your name, sir?
Morning, Your Honor.
Randy Harper.
All right. What are we doing?
Your Honor, in the circumstance, I've had a dialogue with Madam Prosecutor. I'm going to ask for a brief 2-week adjournment so I could potentially solidify a plea arrangement.
Is he in residential treatment?
He actually just got out of residential treatment, Your Honor.
He did. What, 20th or 25th? Well, the 25th or the 4th, I should say.
I'd ask for November 20th, Your Honor.
Probable cause conference, November 20th, 2025, 9 a.m. Bond.
Thank you, Judge.
Thank you, Your Honor.
20th, thank you, Your Honor.
Yes. Court calls the case, people versus Robert. Is it Teacott?
Morning, Your Honor.
Do I pronounce that incorrectly?
Carolyn Foster Tucker on behalf of Robert Sicott. You said your name?
Robert Seacott.
Teacott?
Yes.
Okay, all right. All right, what are we doing
Finally, now in this case.
today?
Yes, sir.
Good. Any objection?
No, Your
Case
Honor.
is dismissed. McNally, thank you, sir. Court does call the case, people versus Adam Atkins.
There's no more assistant prosecutor. People.
Ron Brown, praying on behalf of Adam Mack.
Take your hands out your pocket.
Oh, yeah.
Your name, sir?
Adam Atkins,
All right, what are we doing?
requesting an adjournment.
Do I have a green key?
I'll get it to you.
I'll need one.
I'll get it to you.
Probable cause conference without objection in this matter will be adjourned to decide. 2025, 9 a.m. Bond continued. Court does call the case People versus Cartier Drains. Good morning.
Morning, Your Honor. Mike Gaddy, Assistant Public Defender on behalf of Mr. Drains on case 25F2-1045.
And Sherilyn Foster Tucker on behalf of Mr. Drains in case ending in 1685.
All right, in the case ending 1045, I have a McNally. Is that correct? Any objection?
No, Judge.
All right, that case is dismissed.
Thank you.
And what are we doing on the other matter?
We're requesting a preliminary exam.
All right, discovery is complete,
To my knowledge, yes.
and would the people have their witnesses available on the 18th?
Yes, sir.
Preliminary examination in person will be set November 18th, 2025, 9 a.m. That is before
Judge Washington.
Judge Washington. Bond will continue.
Thank you.
Thank you. Court does call the case of the People versus Omar. Is it Al Galazi?
Trevor, for people.
I think I put those letters in the wrong order. Sorry. Right there. No, we'll wait.
Good morning, Your Honor.
Good morning.
Oh, you need an interpreter? You can choose.
Really? What are we doing?
Your Honor, we're asking for an adjournment today. I apologize, I do not have the green sheet available. I just spoke with the prosecutor in this matter, and I think we are very close to a resolution. Do you need any-
Your name, sir?
Omar Al-Ghazali.
Probably.
And if we,
I beg your pardon, sir. This is our first PCC and we just have to fill out the paperwork and iron out final details. We'll be ready to go next time.
that's correct, Your Honor. And Your Honor, if we can, I'll get the information for an interpreter. My client will most likely need an interpreter. He's using a Google Translate
All right, what
app on his
language?
phone. What language is this? What language? Arabic, Your Honor?
Arabic? Okay, all right. Then I will adjourn the probable cause conference to November 25th, 2025, 9 a.m. That's a Tuesday. So that you know,
Thank
bond
you.
will continue. Thank you. Thank you, sir. Court calls the case People versus Cedric Green.
Trevor Mayville for the people.
Good morning, Your Honor. But please, this honorable court, Brandon Bird on behalf of Cedric Green. Mr. Green, can you please state your?
What, were you hiding over there?
Not really.
Okay, but kinda.
Kind of, a little bit. But,
And you were, I just signed the appointment on this. You needed adjournment.
please, Your Honor.
All right.
Thank you.
Probable cause conference in this matter will be adjourned November 20th, 2025, 9 a.m. Bond continued.
Appreciate it, Your Honor.
Thank you. Thank you, Mr. Green. Thank you. Court calls the case of the People versus Tiger Moore. Bless you.
Prosecuting attorney for the people.
Good morning, Your Honor. James Fatwelski, appearing on behalf of Tiger Moore, who is presently not at the courthouse. I have called him a couple of times and texted him. He is not present. I will say that he is homeless. He has been to every other court hearing. So I would ask the court to consider either adjourning the PCC for 1 week or setting a show cause so he can come in and explain what happened.
Must have been talking to Mr. Gaddy. Bench warrant will issue for defendant's failure to appear. Bonds will be set in the amount of $10,000 cash surety. That warrant will issue immediately. Thank you. Court does call the case People versus Jerry Bigham.
Your Honor. Go for the people. And good morning, Your Honor, and to your staff. May it please His Most Honorable Court, Mohammed Nasser, P74485, appearing on behalf of Mr. Jerry Bingham, who appears standing to my right. Sir, state your full name for this honorable court.
Jerry Bigham Jr.
All right.
Judge, we are in the process of seeking a global resolution in this matter. There are a number of matters also before Judge Slay as well. In light of same, we're respectfully requesting one final continuance to the probable cause conference. I don't believe the prosecution has any objection to same.
That's correct, Your Honor, no objection.
If you're seeking a resolution, do you want something quick or you want me to put it out? I can do the 20th or
May we do the fourth, Judge?
not objection. Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
Thank you very much, Judge.
Thank you. Court calls the case People versus Amberly Almany.
Prosecuting attorney for the people.
Good morning, Anna.
You need to take your hand out of your pocket.
I was putting my phone in my glasses in there.
Just a second, really again.
I was right at the door.
Where?
It's gonna be a better day.
Girl.
It's gonna be a better day, Judge. Your Honor, Assistant Public Defender, tonight be carried really on behalf of Ms. Almany. We are asking for.
Can you
an-
state your name, please?
Amber Almany.
Thank you. All
Judge,
right,
there
go
is a resolution. The people have asked that Ms. Almany take a class. So we want an adjournment to allow her to get that class and see if it can help with our negotiations.
Okay, and how long will she need to get that done?
I'm gonna help her find it. It's a gun safety course, Your Honor. I think it's a one-day class that she can take. So 2 weeks is fine with us, Your Honor.
She's gonna be able to get into a gun safety class in 2 weeks? No, she might. I don't know what they're gonna teach her, but anyway.
Whatever.
Why don't I do this? December 4th.
That is fine, Judge. Thank you.
2025, 9 a.m. Apparently you've never taken one of those. Ms.
I
Elkins,
have
right?
not.
No, I can tell. All right. I'll do that. All right, and you, of course,
All right.
have no green sheets this morning, apparently.
You know what, Judge? Somebody drafted them for me. They're not in here, so I'm gonna get them.
Oh, you're gonna throw somebody under the bus? Because
I
they,
just said
no,
bye.
it's somebody else's responsibility.
Get 'em to
I'll
the-
await them, and then when I get them, I'll sign off on all of them, apparently. Thank you, ma'am. Bond
Thank you.
continued.
Thank you so much, Your Honor.
Court calls the case People versus Brian Neal.
Ready, Your Honor.
Prosecuting attorney. James Fifelski, attorney of record for Mr. Neal.
Good morning once again, Your Honor, and to your staff. May it please His Most Honorable Court, Mohammed Nasser, P74485, also appearing on behalf of Mr. Neal. Sir, please state your name for the record.
Bryant Michael Neal.
Judge, may it please the court?
Yeah, you're on this,
We got retained. We filed our appearance. However, a substitution didn't make it to the file. I did speak to your fine clerk as well. So in speaking to brother counsel, he has no objection. I will file a substitution of counsel. And we'll do that.
You would need that.
Yes, Judge. And we're requesting a continuance of the PCC. I've spoken to the prosecutor. Discovery is voluminous. I know that Mr. Neal does have a copy of the discovery. Be that as it may, I needed to review. So may we have the same date, Judge, of the 4th?
Any objection from the people?
No.
Probable cause conference, December 4th, 2025, 9 a.m. Bond continued.
We'll be here, Judge. Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case People versus Cortez Fairley.
Morning, Your Honor.
Sorry to wake you. No, go ahead.
Actually, I'm pretty much dozing off. Mr. Fairley? Judge, I was just appointed yesterday, so I'm not real familiar with Mr. Fairley. Is Mr. Fairley audience? Judge, I'm sure he's here, but he just doesn't want to respond, so
Is that right?
I would like to ask for a 2-week adjournment.
You would. So you've asked and denied.
You being a considerate judge,
Yes.
you are.
Bench warrant will issue for defendant failure to appear. Bond will be set
Would you consider a show cause?
considerately in the amount of 10,000 cash shared. Excuse me?
No show cause?
You know what? Daddy, where's Daddy? He is? He may stay there. People keep asking. Or we'll issue immediately. Thank you.
Thank you for your consideration.
Court does call the case. Other people versus Devontae Gambles.
Overwater Assistant Prosecutor.
Good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Devontae Gambles.
Wendy Barnwell, P 42505, withdrawing, file a motion to withdraw. As permit for gambles.
Got it. Okay. I will permit that withdrawal, given the circumstances. Right.
Your Honor, I've just been appointed to the case. I'm just asking for a week adjournment, Your Honor, to just get caught up, so. I think there's a green sheet in there, Judge.
There is,
Okay.
unlike Ms. Akinrule. Probable cause conference will be adjourned to the 13th. November 13th, 2025, 9 a.m.
Thank you, Your Honor.
Your name, sir?
Devontae Gambles.
Thank you. All right, thank you. Bond continue.
All right.
Court calls case People versus Dwight Miller.
Okay, Mr. Miller, it's my understanding, Mr. Miller, is Mr. Miller, I don't know what you're showing us, but what, would you state your name for the record?
American State National. All my rights have been violated. They can't.
Did you
produce
state your
weapons.
name first?
American State National, man. Your
Okay.
Honor, I've been asking for the whole time, man. There ain't no firearm. There never was a firearm. I was kidnapped. My rights was violated. The lady lied on the scene. She said she called the police, said somebody pointed a firearm at her. Then
Sir?
when the police came on the scene,
Sir?
she made that
Sir?
statement again, and then it was
Sir?
proved. The cameras proved none of that happened.
Sir, if you overtalk me, you can. It's not going to work.
Dwight,
It's not the time for you to try to litigate your case.
Where's the
Dwight,
firearm?
Dwight, just listen. I was just appointed yesterday. Mr. Gaddy gave me the discovery this morning. Why don't we ask for a 2-week adjournment and you and I can talk?
Where's the firearm? Where's the so-called person that's the victim that signed a sworn
Any
affidavit?
objection from the people?
No, Your Honor.
Probable cause conference will be adjourned
I object.
to
I object. I
November
object.
20th.
I object. I object. I don't get
Objections
consent.
noted and denied.
You violate my
November 20th,
constitutional rights.
2025,
I
9
ain't about to
a.m.
write you up. I'm
Bond,
about to send up
bond
a
will
judicial
continue.
review.
And you know what? So
I'm about
let's
to
do
send
it this
judicial
way.
review.
That hearing will be in person. So if
Uh,
you got
my
something to
back
say, you
messed
can
up.
come right here and say,
My
in person.
back messed
Thank
up.
you.
know
Mute
that.
him.
You know my back messed up.
You're welcome. Court does call the case.
Well, my back messed up as well. Good morning, everybody. It's the Courtroom Files live on a Thursday. Yeah, my back is messed up, actually. It's been kind of off the last day or so. We are here hanging out. Michael Groff in for Dan Soul. We've had some fun this morning with Judge Simpson. Yeah, I suppose we'll hang out here for just a little while longer. Got a number of courts coming online. We've got all sorts of stuff we can get to, but let's keep it here, see what's going on with Judge Simpson, just for a little while longer. Or he'll go private. Well, then there's that. Okay, Judge, I see how it is. Well, you know what? We didn't, I don't think we checked in with Judge Dad yesterday. Let's go over there. Let's see what's happening. Keep it in Michigan. See what's happening with Judge McNally. Do we not have sound? Okay. Well, that's my bad. All right, hang on, folks. My bad. Well, actually, that's not my bad. That is the bad of StreamYard, apparently. Let me fix this. Okay, we you know what? We made it like 2.5 hours yesterday without an audio issue. Every court I was watching yesterday was having audio issues as well, and now I was like, so it's good to know that I'm not the only one. Okay, so we're gonna reload. We're gonna go back up here, and we're gonna go over here. All right. Let's try this again. My apologies. All right, Judge McNally.
Ms. Boozer, did you need to see me again?
Yeah.
Hang on. I gotta call your case. Leah Devon Boozer, 25T 644-894. You got those messages for me?
We'll keep getting call records for the last 60 days.
You didn't call. Ma'am?
Judge,
Yeah.
I did go through our call log while we were waiting. I do have a call from her on August 8th, which is past the due date. We left her a message with all of her options of a defaulted ticket.
Oh, I know I did.
Well, they went
Thank
to,
you, appreciate that.
that was late. And then they called you. Did you hear what she said?
Yeah.
Okay, so you didn't call here 10 times and you didn't call within the time period. Why did I know that was going to happen? Listen to me very carefully.
Okay.
Be honest with me. Ma'am. You told me you called 10 times. You didn't call 10 times. You called after the due date. You were in default. They told you how to go about it. And you didn't do anything. Now, I don't want to quarrel about this. I don't understand why people don't understand that you're going to get so much further with me when you're honest. I just don't like dishonesty. But that being said, let's put that aside. How much can you pay today on this?
I don't have nothing to pay today.
How are you supporting yourself? How are you supporting yourself?
I have like side jobs I do. I have a job. So I can pay.
Do you have kids?
$25. Yes, I do.
Is the father in their life? Is he paying you child support? Does he work?
I don't know.
Go to the friend of the court. These guys can't have kids and then not support them. That's not the way it works in this country. You pay 25 a week, you said?
Can I pay like 25?
A month?
And then whatever extra I can pay on. How much is the total ticket?
You owe $213.
Okay.
I mean, you're asking a lot. This means it's going to take you 9 months to pay this.
Well, I can do what I can. I'll be honest.
How old are your children?
8 and 7.
They're in school?
Yes.
Why aren't you getting a job when they're in school?
Yes, I just have him.
Gotta work. You don't want to be in poverty your whole life. I'll let you do this. You pay 25 per month beginning December 1. If you don't have the money, you call the court, you go on or before any due date, the first of every month. I expect you to pay 25, or if you can't, you either come in here, drive in here at 8:30 in the morning, and I'll give you an extension when you ask for it, or you call the court. We'll go on Zoom at 8:30 in the morning, but you can't ignore courts like this, man. Okay? Good.
December 1st.
The first of every month, starting December
Do I
1st.
get something that I know how to pay it or?
Yeah, go down the hall. They'll help you out.
Okay.
They're busy down there, so just be patient.
Okay, thank you.
Priority waste, 25T 646-790. I have A and B and C. All right, so. Mr. Dillon, good morning.
Good morning, Your Honor.
So on the B file, the miss your appearance
Good morning, Your Honor. Alex Dillon on behalf of Priority Waste,
on
P526.
I'm sorry. Go ahead. My apologies.
I think, no, we're good.
All right, so does the company stand mute, wait formal reading on misdemeanor?
Yes, Your Honor.
And then the company's going to plead to file A, which is a civil infraction of misload, with agreed upon fines and costs of $540, true?
True.
And then also that the company's going to plead on file C, prohibited truck route. I'm sorry, they're gonna plead to impeding traffic on that file, right?
Yes, Your Honor.
And then court's going to go ahead and dismiss the prohibited truck route, which is file C, and the court will dismiss file B, dismiss file C, at least as the original charge with the plea to impeding, and then as to file A 540 on the misload. True?
True.
Charge of misload on behalf of the company, responsible or not responsible?
Responsible.
And on file C to impeding, responsible or not responsible?
Responsible.
All right.
Your Honor,
Just let me accept the pleas first,
Okay, all right.
and I'm going to dismiss the original charge on file C. I'm going to accept the plea to impeding, accept the plea to misload, dismiss the operating without proper endorsement. What, you need more time?
yeah, Your Honor, we know what we owe and it's a lot, but we did pay a fair amount yesterday and over the years, we have been a very good payor. So I agree with you. I don't want to kick cans down the road just for more time. So if you could just give us maybe 90 days.
90?
That'll help. What's that?
90?
80?
I'm saying, is that what you said? 90? Is that what you're asking
90
for?
days. So that way I accomplish what my client, a little time to fill the coffers.
All right, I'll do that. Pay by, so 540 on the one file and 185 on the impeding, and I'll give them till February 6th of 26, okay?
Awesome. Thank you, Judge. Appreciate
Good
it.
day. You're a pleasure to deal with, Mr. Dillon. Take care. Thank you. Catherine Denise Feisick? 25G306680. What's that?
You said it right.
Did I?
Yeah, no.
Ding, ding, ding. Too bad I wasn't on Jeopardy, and that was the final Jeopardy question. Come on, up here. Who's Catherine Denise Feisick? You are?
Yeah.
What's your name?
Catherine Denise Tyson.
And who's this? Your lawyer, your bodyguard? What is she?
Daughter, and at the ticket, I was driving the car.
You don't need to sit here and tell me that. They issued it to the wrong defendant, so you're dismissing the case, right? Why are you sitting up here and spewing that you were driving? You'd make a lousy criminal, you know that? Prosecutor moves to dismiss. Prosecutor moves to dismiss. Case dismissed, motion of the prosecutor. Take care. Have a good day. Thank you. All right. Sarah Nicole Francis. Soik. 25G306677. A and B. I don't know what he means by this. Your name?
Sarah,
You're going to plead impeding traffic on file A. And then it says no agreement can be reached on this other one. That's on the obstructed vision. Are you pleading to that too?
He told me I had an option to either take points and.
No, I get it. I need Robinson in here, John, if you know where he is. I'm just not understanding how he wrote this up. Looks like he's having you plead to impeding on A. And then on B, it says paying this and reducing a file. So it looks to me like he expects you to plead on the obstructed vision. That's 2 points too, though, you know.
That's not what he told me.
Well, let me get him in here. We'll clarify this, okay? Just bear with us.
He's on one.
Okay.
Thank you.
Good morning, Sergeant. How are you? Your name?
Roll, please.
You don't have to raise your right hand.
Say hi then.
Oh, yeah. So on the A file, you got impeding here and the speeding to be dismissed. And then it looks like you checked no agreement can be reached on the B file. That's obstructed vision. Then you said, oh, they're paying this and reducing A file.
Yes, Your Honor. So she was going to pay the, obstructed vision that were to drop the impeding traffic, or drop the first one, the impeding traffic.
Right. So, but I want you to understand, she didn't seem to understand this. Obstructed vision's 2 points. Do you understand that?
I
Okay.
just didn't want points, that's why I asked for the hearing.
I can see if we can find like.
What's her record like?
Get a couple crashes on there, like 22, 24.
You feel the yield is a hazardous action in 22. I mean, you could just do 2 impedings. It's up to you.
Okay. That way there's no points on there. I appreciate it. Yeah, if we can do that then.
Can you change this step form for me, please?
So 0 point, so.
That's okay.
Thank you.
So you're going to plead impeding on file A. They're going to dismiss the speed, true? To the charge of impeding traffic on that, responsible or not responsible? All right, and then on the file B, he says he's going to reduce that to impeding. I just want to take a quick peek there. You're going to plead impeding on that, right? To that charge, responsible or not responsible? All right, I'll accept those pleas to impeding, dismiss the obstructed vision and the speeding. On the speeding, you're going to pay 155. On the obstructed vision, 125, 280. You can pay that today?
Yes.
Go down the hall and take care of that. You better thank this good young man here.
Thank you.
Have a good day. Daniel Giles. Okay, good enough. Who was it? Do you know, sir? Okay, that's fair. What's that?
Did you talk to the attorney? You talked to him? One of the crutches, that's all I know.
Okay, Mr. Gage.
You should. Yeah, he already talked to him, so you should have a file, right?
I do, but it's not in here.
Oh,
Is Maxon in here? Did you have a lawyer?
they all spoke the game. I don't know. I got.
Okay.
They judge me changing. All right. He's calling cases right now. Okay. He said 1 minute, yeah.
Okay. Is there a conditions of bond sheet?
Yep.
Thank you.
I've been trying to hand you for 2 days. I'm glad you finally need this. Time you asked for a form, I'm like, you want this? You want this one? No. That's fine. The only one that was close to me, so I was like, he must use his son the other day.
Give me 1 second, Mr. Gaith.
Sure.
It's Neil Curtis Giles, 25T 646-053 A and B.
Good morning, Judge. Matthew Gate, here on behalf of Mr. Giles.
Sir, again, you can have a seat there if you'd like. whatever, you want to have a seat? Pardon?
Daniel Giles?
I just want to make sure. Do you want to have a seat?
No.
All right. Lisa, I'm just gonna end on the order here, A and B files, There's two different counts. I just want to make sure they. Two charges of assault and battery. How does he wish to proceed?
We'll stand mute, wait, reading, Judge.
All right, I'm entering a not guilty plea. Anything you'd like to say regarding bond?
Judge, we'd ask for a personal bond. Obviously, Mr. Giles is here to take care of this matter, and he doesn't have a significant criminal record. And we'd ask for.
How does that be? Not a significant criminal record. He has a criminal record, just not significant.
Well, I misspoke. I don't believe he has a criminal record whatsoever.
I'm just kidding. I'm just kidding. All right, listen to me very carefully. I'm gonna give you $1,000 bond, personal bond. You cannot leave the state without the consent of the court. You cannot violate a law. You're not to have any contact with Nicholas, Katie, and or Benjamin Forrest. You cannot write, phone, see, text, email, or communicate with them or have anybody else do any of those things for you or on your behalf. No phoning, no seeing, no communication of any kind. No contact with prosecution witnesses except through your lawyer. You're not to possess firearms. No firearms. No dangerous weapons. You're required to go over to the Trenton Police Department to be fingerprinted and photographed by 1 p.m. today, and you're not to go near Corwell Hospital. Do you understand that? All right, good enough. So we'll give you a new pre-trial date. You're gonna have to fill out a petition for a court-appointed lawyer going forward. Where do you work at? When did you last work?
Haven't worked since October 1st.
Where were you working before October 1st?
Station.
What happened on October 1st? Okay, wait. Let me just, oh yeah, that was the incident date. Okay. Don't answer any more questions. Lisa, give me a new pretrial. Are we gonna do the 20th?
November 20th at 9:45.
At 9:45. We're gonna give you a copy of the bond sheet. You're gonna have to fill out a petition for a court-appointed lawyer. We're gonna give you a copy of the order for print. You have to go over to Trenton to get fingerprinted and photographed by 1 p.m. today. So you're gonna go down the hall, get your notice, get those documents, and then come back on the 20th. And go to Trenton today for prints. Good luck. Aiden, Paige, Max.
It's the Courtroom Files Live. It's Thursday morning. Good morning, everybody. Thank you, Barbara, for the $5 super chat. I really do appreciate that. That helps us out. And of course, if you guys want to hang out, join us in the chat. That would be awesome. That's why it's there. This is the best community in all of LawTube. And I don't just say that because I'm a participant here. I don't just say that because I'm filling in and hosting. I am part of the community here as well. I love this place. It's a wonderful community, and you won't find that very often on the YouTubes. That's for sure. All right, let's see. Let's head down to Florida. We've got first appearances going on down here, or these aren't first appearances. I think these are violation of probations. This is a different judge than we normally see. This is Judge. I believe this is Judge Patterson.
Good luck to you, sir. Thank you.
So we'll see what he's got going on this morning.
State of Florida versus Brian Taylor, case number 23653 CF.
And good morning, Mr. Taylor.
Good morning.
All right, Mr. Green.
On behalf of Mr. Taylor, we move to withdraw his formal plea of not guilty and enter a plea of no contest to violating probation. Agreement with the state subject to court's approvals, his probation would be modified to include inpatient drug treatment successfully completed at the Haven House Mission. We would stipulate to a factual basis as to the violation to be $500 added to his monetary obligations for this violation. All prior and complete conditions would be reimposed.
And is that the understanding with the state?
Yes, it is, Your Honor.
All right, sir, if I could have you raise your right hand. Do you solemnly swear or affirm the testimony you present here today will be the truth and the whole truth, so help you God? Yes, sir. All right, thank you, sir. You've heard the announcement of your attorney. Is that what you wish to do here today?
Yes, Your Honor.
And again, I do note it is case 23 CF 653 for the record. You have given to me a plea form. Is that your signature, sir?
Yes, sir.
Did you have a chance to go over this with Mr. Green?
Yes, sir.
Was he able to explain to you the various rights that you have and the rights that you're giving up by entering this plea?
Yes, sir.
Any questions about what you've signed and agreed to?
No, sir.
Are you satisfied with his services as your attorney?
Yes, sir.
And is anybody forcing or threatening you to enter this plea?
No, sir.
Do you believe that this plea is in your best interests?
Yes, sir.
And are you today under the influence of any medication, anything that keeps you from understanding what you're doing?
No, sir.
Anything further from the state? I have heard the stipulation.
Nothing further, Your Honor.
All right, very well then, Mr. Taylor. I am satisfied based on your testimony that your plea here today is freely, voluntarily, and intelligently made. It is made upon the advice of competent counsel with whom you say you're well pleased, and there is a sufficient factual basis to accept your admission, and I do so at this time. As to sentencing, I am going to sentence you in accordance with this plea agreement, but is there anything else you'd like to add?
Just one question, I guess, of clarity. I was on probation in a different county, and it was I was put off to today to try to come to a global resolution with them, but I guess that is in a different circuit. That can't be done.
Well, if there wasn't an agreement before today, no,
Then
there
no.
it doesn't sound
So
like there was. So-
I have to go to Walton County then, and then I would go to this program.
Correct,
Okay.
correct. I don't know if there's a hold out of Walton County on him or not, counsel, but that typically is what they'll do.
Okay. And will they be aware that I'm sentenced to a program?
They will.
Okay.
They will.
All right.
I can't make any promises about what they do with
Right,
you
I
over there, but,
understand.
okay. Does that change anything about what you
No,
do
sir.
today?
No, sir. Thank you.
All right, very well. Then I am going to modify your existing supervision to add the additional requirement that you complete the inpatient treatment program at the Haven House Mission. I'm ordering additional court costs and fines in the amount of $500 over and above what was previously ordered. And I now reimpose all incomplete terms and conditions of your supervision upon you. You do have the right to appeal if you desire to do so. You need to file a written notice with this court within 30 days. Any questions?
No, sir.
I don't need you fingerprinted. I'm not adjudicating you guilty, just modifying. So good luck to you, sir.
All right. Thank you.
Thank you.
Yep. You ready, Your Honor?
Yes, sir.
Your Honor, next case before the court is James Christopher Williams, case number 23598. Your Honor would like to bring him back on December the 4th to see if we can get it resolved. If not, we'll have a hearing on January the 6th.
All right. Any objection by the state? All right. Very well then, Mr. Williams. We'll bring you back in December. Let your attorney see if he can get a resolution for you. And if not, we'll get you a hearing date as well. Thank you, sir.
Your Honor, next case is for the court of case of State of Florida versus Stormy Blair, case numbers 23504, 505, and 506. And I think she's for hearing on December the 4th.
All right. And I see Ms. Blair is with us. Good morning, Ms. Blair. I'm Judge Patterson. Your attorney has indicated that you've got an evidentiary hearing set for December 4th.
No, sir. I
Do you
never
have a-
said that
Do you have a plea agreement with anybody?
there was a plea for 36 months, but I had an offer to go to rehab and it was my only, this is my only violation. I wanted to see why I wasn't able to go to rehab. I never said that I wasn't going to sign for the 36 months. If my rehab wasn't going to be, it was a year rehab in Destin and a year transition afterwards. It's a 3-year program.
Well,
But it-
here's the problem. Here's the problem that the court's in. I can't negotiate a deal for you. That's beyond what I'm allowed to do. So I'm told there is no resolution today. So it sounds like I've got to get you and your attorney back together to talk about this because I can't do anything today.
I'll sign my 36 months, but I don't have to go to court in December to sign my 36 months. All he got to do is bring my paper and I can sign for I'll sign to go to prison. The prison part wasn't a problem. It was the part of me needing, I needed help.
Well, and again, it does not sound to me like there is an agreement between the state and yourself yet today. I've not heard a thing that says there's an agreement. So I can't just do it on the fly like this.
There was a plea deal for 36 months.
Okay, well, I don't have that before me. So that's the
Well,
problem. I don't
shouldn't my
have any,
lawyer have it? I
I
mean, he
don't, I
came
don't have a
yesterday
plea
with,
deal. Mr. Keel, can you help me maybe?
Yes, Judge. So we are scheduled for an evidentiary hearing on December 4th. The state is prepared to go to an evidentiary hearing on that date. The state's offer, just for clarification, I gave actually a 30 months DOC offer. She has a new law out of, I believe, Calhoun County, and that was a global offer, 30 months DOC. She has already been sentenced to an inpatient drug treatment program in the past. So we're not offering inpatient drug treatment at this time.
that's fine, but I never refused my 30 months. I never understood, half
Mr.
of the
Green,
stuff that.
Mr. Green, and hang on, let me just take a second, Ms. Bear, if I could. Mr. Green, I'm in a bit of a quandary because obviously I can't verify that you've discussed with her the plea form or anything at this point. So what would you have the court do? Maybe we can bring her back to a first appearance and take care of it that way.
We may be able to, Your Honor. I've got something in writing said that she didn't want the things that she's talking about now.
I never,
Well,
I never
let's
signed
do this.
anything saying I didn't want it.
Well, here's what I'm gonna do, Ms. Bear, because again, we do have some flexibility. If I can bring you back, I'm gonna set it for December 4th, but Mr. Green can put it on any morning at first appearance, and either myself or Judge Garcia will step in and discuss the matter with you. So I want to give him a chance to come out and see you at the jail one more time. Have you signed any documents based on what the state has presented today? And then we'll go
No,
forward. But
I didn't sign or deny any documents.
I understand. I understand. So that's where we're at. Nothing's been signed or denied.
Okay.
So at this point, it's December 4th. So Mr. Green knows how to get you back on the docket very quickly. So hopefully he'll be out there to see you, and then we can hopefully have you back here in the next day or so.
Okay, thank you.
Okay, thank you, ma'am. But for now, it'll be December 4th. Until Mr. Green, you tell us otherwise.
Your Honor, next case is State of Florida versus Iona Best, case number 24-410 CF.
All right, and good morning to you, ma'am. Good morning. Counsel, where are we on this?
Your Honor, we don't have a resolution yet. She has a new law violation in Washington County for some marijuana, I think. And we're trying to come up with a resolution, global plea for if we can. I'm sorry, is this already finished? I'm told that one is finished, Your Honor.
All right, so what would you have me do?
She's supposed to, like to bring it back on 12/4, where she will sign up for 6 months inpatient drug treatment. That's what we need to do.
All right, counsel for the state, is that your understanding of what may be offered?
Yes, that is currently the offer that I have on the table, and no objection to bringing her back on December 4th.
Okay, all right. Ms. Bess, what we're going to do is we'll bring you back December 4th. And Mr. Green's going to be out to talk to you about the plea offer, have you sign up, and then try to get you back before the court earlier than that if possible. Yes, ma'am.
That was not, it was not, had nothing to do with Washington County. I'm done with that. It was Bay County, and it was to see about it being ran concurrent. And I was not supposed to come back on December the 4th. They said they would get me in at first appearance, if possible, after they tried to get it concurrent ran with Bay County, which my charges are already ran concurrent before I even violated.
Well, that may be the case. I just don't have a signed plea form today. So I can't do anything for you today. And I have no understanding. Hang on. I have no understanding about any global resolution between Jackson and Bay County today. I don't know that. So, state?
I can clarify a little bit. There has been no discussion regarding a global plea when it comes to Jackson and Bay County. The sole violation for her Jackson County VOP case was a new law charge for possession of marijuana she picked up in Washington County, which she has since entered a plea into. That's the only violation we have right now. If there is a potential for a global plea offer, I'll see if I can get in touch with somebody from Bay County.
Okay, all right. Well, Ms. Bass, I have no choice but to set you for December 4th. But if we get a resolution ahead of time, we can always bring you to first appearance, try to let you resolve all the cases at one time. Thank you, ma'am.
Your next case, State of Florida versus Robert Carlton, case number 2356 CF.
And good morning to you, Mr. Carlton, and Mr. Gill for the state council.
Your Honor, we would like to bring him back on December the 4th.
All right, is that the state's understanding, at least at this point?
Yes, no objection to that.
All right, then we'll set Mr. Carlton for 12/4 for resolution or subsequent evidentiary hearing going forward. Your attorney will be in touch, sir. Thank you, Mr. Carlton.
Same thing. Your Honor, next case is State of Florida versus John Chilo, case number 24148 CF.
All right, and good morning, Mr. Shido. Mr. Green?
Your Honor, I'd like to bring him back December the 4th. If we don't resolve it, have a hearing January the 6th. I think we're real close. I think we'll have it
Is that
resolved on
the
the 4th.
state's understanding as well?
Yes, Your Honor.
All right, well, let's set Mr. Shido for 12/4. And then if there is an earlier resolution, we can always bring it back ahead of time. All right,
Yeah, I thought
thanks, sir.
I discussed about going to the Keaton House for the prom the other day with the counselor, and I thought that's what we had lined up today.
Well, unfortunately, as the court, I don't have a signed plea agreement.
Your Honor,
So-
yes, excuse me, he has to be screened for that, and that's why it's not completed yet.
Can the court assist in directing that he be screened, or has that already happened, or?
Hear that.
I don't.
Anyway, okay, all right.
We're trying.
All
to
right,
get
well, at this
him
point, I'll bring him back on the 4th of December, and if there's a resolution ahead of time, get him to first appearance if you
That's
can.
right.
Okay. All right, thank you, sir.
Our next case is State of Florida versus Lee Edwards, case number 21544 CF.
And Mr. Edwards is with us remotely. Mr. Green?
Mr. Edwards is scheduled for a hearing on December the 4th.
All right, and is that the 1:30 hearing date?
Yes, Your Honor. Usually we bring them in the morning and the afternoon in case there's a resolution.
All right, Mr. Edwards, then we are setting your matter for an evidentiary hearing on December 4th. We'll bring you at 9 o'clock. If there is a resolution, then it'll resolve at that time. If not, we'll have the evidentiary hearing at 1:30. Thank you, sir.
Our next case is State of Florida versus Tyrone Godfrey, case number 22347 CF.
And Mr. Godfrey is appearing remotely. Mr. Green?
Your Honor, we're close on this, but it hasn't been completed. We'd like to bring him back December the 4th and hope to have it completed at that time.
All right. Is that state's understanding or any objection to 12/4?
No objection, Your
All
Honor.
right, Mr. Godfrey, I am being requested to bring you back on December 4th. Sounds like negotiations are continuing. And if there is no agreement, we'll have the evidentiary that afternoon. Presumably,
Think so.
No.
No? Okay.
12/4. Okay. All right, Mr. Godfrey, 12/4 will be your next court date unless there's a resolution ahead of time. Thank you, sir.
Your next case is State of Florida versus Joe Harris, case number 15526.
And Mr. Harris is with us remotely.
Your Honor, Mr. Sims, my boss, has filed a conflict in this case.
All right, and has that been filed with the clerk already?
Yes, Your Honor, 11-4.
Okay. Let's get Mr. Harris then. I've got to get him an attorney, so we'll look at, and I presume he is indigent, Madam Clerk? Okay, so let's get him a registry attorney. And then let's set him for 12/4. Let him talk to his lawyer and then we'll see where we go from there. But I do want Mr. Harris to have an attorney first. So, Mr. Harris, I'm gonna get you a private attorney. We'll get him on the case here. I'll send an order, sign an order today. And there'll be an attorney coming to talk to you soon. Thank you, sir.
Your Honor, there was also the order of recusal for Judge Garcia. I don't know if that's been handled yet, but just want to bring that to your
All
attention.
right, I know it's not reached my desk in the administrative capacity
I
yet.
gotcha.
So, okay. All right, counsel.
Next case, Your Honor, State of Florida versus Courtney Helen Jones.
All right, and Ms. Jones is with us remotely from the jail facility here in Jackson County. Mr. Green.
Your Honor, on behalf of Ms. Jones, would move to withdraw a formal plea of not guilty and enter a plea of no contest to violating probation. The agreement with the state subject to court's approval is she would, the court revoke her probation, sentence her to 24 months in Department of Correction with credit for 159 days. She would request a prison in or near Tallahassee after the reception center, but does not want Gadsden County. To be $500 added to her monetary obligations and civil judgment for any unpaid monetary obligations.
And is that the understanding with the state?
It is, Your Honor.
Very good. All right, Ms. Jones, you've heard the announcement of your attorney. If that's what you wish to do, I need you to raise your right hand and I'll swear you in. You solemnly swear or affirm the testimony that you present here today will be the truth and the whole truth, so help you God.
Yes.
Thank you, ma'am. You can lower your hand. You are Courtney Helen Jones,
Yes, sir.
and you've heard the announcement of Mr. Green. Is that what you wish to do to resolve both of these cases?
Yes, I do want to double check and make sure that it is my time served, because when I did calculate from the other times I have been here from the original charge, it all equaled up to 190 days credit.
Okay, well, the agreement says 159. So if that's, if it's 159, does that change your, well, let me ask you this. You say you want to check that. Are you gonna, do you want to delay this proceeding this morning, or what are you asking me to do?
No, I just wanted to make sure that it was the correct days that I'm being served. I'm gonna do the Department of the Corrections. I am gonna go to prison. So I can go ahead and get it all done.
Mr. Green, can you give me any guidance on the time served, or? Oh, okay. 159? Yes. All right, our court staff and our jail staff are telling me 159 days, Ms. Jones.
Okay.
That change your mind about doing this today?
No, sir.
Okay, I have a plea form. It appears to bear your signature. Did Mr. Green go over this form with you?
Yes, sir.
And do you understand what you're signing and agreeing to? I'm sorry, I couldn't hear you, Ms. Jones. You understand the agreement? and
Yes,
what you're
sir.
agreeing to? Anybody forcing or threatening you to enter this plea?
No, sir.
And do you believe that given all the circumstances, this plea is in your best interest?
Yes, sir.
Are you satisfied with your attorney?
Yes.
Are you on any medication or anything that keeps you from
No.
understanding what you're doing here today?
No, sir, I'm not.
All right, and again, is there a stipulation, Mr. Green? Okay, all right. Anything from the state? All right, very well then. Ms. Jones, I'm satisfied based on your testimony that your plea here today is freely, voluntarily, and intelligently made. It is made upon the advice of competent counsel with whom you say you're well pleased, and there is a sufficient factual basis to accept your admission, and I do so at this time in both of these cases. Anything you'd like to say before I impose sentence?
No.
All right, very well then, Ms. Jones. I am going to sentence you in accordance with this plea agreement. I do revoke your supervision in both cases and adjudicate you guilty in both. It is now the sentence of this court. You'll be sentenced to serve a term of 24 months in the Florida Department of Corrections with credit for 159 days. That'll be on both cases, concurrent one with the other. I am going to impose additional court costs and fines in the amount of $500, but I reduce all court costs and fines to a civil judgment as against you. I will recommend your placement as near to Tallahassee as is practicable. But of course, the Department of Corrections ultimately makes that decision, but I'll make that recommendation. I will note that you do not wish to be placed in Gadsden. But again, I can't control that going forward.
Well, either way, it's fine because I've learned that I've already talked to my people and the people that I was supposed to be around are no longer at Gadsden. So Gadsden County is fine.
All right, very well. Thank you then for that. You have the right to appeal if you desire to do so. You need to file a written notice with this court within 30 days. I will need to have you fingerprinted out there at the jail. Good luck to you, ma'am.
Thank you.
All right, it's the Courtroom Files Live. It is Thursday. I am Michael Groff. Apparently, I'm just getting started. I haven't really had breakfast yet. This is, so far, this Coke Zero is my breakfast, as is water. I did have some coffee about 3 o'clock in the morning. So I'm still kind of getting fueled up, I guess. All right. Once again, thank you to everybody hanging out in the chat, spending the time with us. Really, really do appreciate it. We're back here tomorrow, of course. And then Dan will be here on Monday to fill back or to, well, retake his rightful place here. I am just keeping the seat warm for him. And then I think next Tuesday, it's a holiday, so I don't think we're going to have a live show, but who knows? Dan is probably chomping at the bit. Maybe he'll do his own special show for us here. I mean, who really knows? So, with all of that having been said, let's change things up here a little bit. Let's go to Texas. Well, maybe get a little bit heavier here.
Tyrone Parker.
Let's see what's going on with
That's you,
Judge Stevens.
25 CR 1243. You are Tyrone Parker. Yes, sir. You're charged with a DWI, a third-degree felony of driving while intoxicated, but it doesn't stop there. It's even worse than normal here because generally a third-degree felony carries with it up to 10 years in prison because of prior convictions of DWIs, 2 or more. Prior convictions, if you get another driving while intoxicated charge, then you're looking at up to 10 years in prison. I see you have the indictment states you were convicted of robbery in 97 in this court. And after that was final, you committed the offense of illegal possession of cocaine and were convicted in the 337th Harris County Court in 99. If all of this is true, this isn't a third-degree felony punishment anymore. You're looking at no less than 25 years to life imprisonment, habitual felon status. Why you would even flirt with trouble when you've got 2 prior convictions and another felony the rest of your life puts you in an automatic up to life in prison. Why you would flirt with trouble is beyond me, but you did it. You made a mistake and here you are. Attorney, you told me last time that you were hiring Rife Kimber, but I don't, the person who has Rife Kimber in this court doesn't know where he is right now. So do you know where he is?
Well, they went to see him Friday, but Friday was Halloween. So we talked.
So he was out trick-or-treating?
I guess he was.
He was?
Wasn't in. So I'm supposed to go see him tomorrow.
Did anybody recognize Mr. Kimmler at their house?
So it looked like
those are masks.
Yes, sir.
Okay. You hadn't talked to him lately?
Wednesday, Friday.
Yeah. Did you hire him?
Oh, he wasn't in on the 31st. I'm going to be on the 6th.
Well, he's not gonna be here until he gets paid. Probably. That's the way they normally work. You get 1 week to get him in the game. Or else we're gonna do something else. Okay, what about you? Did you drive up here? Who took you?
Because
who's that?
He's outside.
Okay, you understand you can't operate a motor vehicle unless you have an interlock device. If you're allowed to operate, I don't know what the bond is if another judge has set a bond condition where you cannot operate a motor vehicle, but you don't have just 2 prior convictions that are serious. You got 3. Yeah, I'm looking, you have harassment of a public servant. You have 3 prior felony convictions in sequence. So you were a habitual felon 1 conviction ago when you had 2. So I'm sure the judge probably warned you about the consequences. What was the blood draw? The result, please, from the state? Thank you.
0.139.
I'm giving you one week to talk to somebody, and we're not going to wait on them. We're going to move forward, and think about hiring somebody else if you can't get him. Okay, all right. Get a resetting for 1 week. Thank you.
All right. Well, the next contestant comes on down. Just a reminder tonight, 8 p.m. East, 5 p.m. Pacific, right here on the Courtroom Files YouTube channel. Join us for Sidebar. Star witness or liability? Yes, we'll be talking about witnesses tonight, how key they can be for you or against you, or how your own witnesses can mess up your case. Well, we'll talk about that tonight on Sidebar. Now back to Judge.
Should be.
Your Honor, there's a letter
should
of
be
representation in the file from Mr. Kimler.
Okay, help me out.
I believe it was back in March.
All right. Go to the short form version. What does it say?
That Rife is retained on this case.
Oh, okay. He's been in the game a while. Have you talked to him? Not like today or yesterday or something?
I talked to him like when I was sick in COVID.
Okay. But we're about to pick up a trial, and he was supposed to be here at 9 o'clock, and I'm sorry, but you're not gonna, I think your time has been wasted, which shouldn't be. The attorney should be contacting you and you communicating, and you can be with you and communicating with him. You paid him a fee to represent you, and you're here by yourself.
Your Honor,
Resetting.
it should be noted that
20 minutes ago, sir. Thank you. Do you have anything to say with for this lady? Because I've got to get back into a trial. That's why we set these dockets at 9 o'clock. I know you saunter in late, but we're ready. What's your announcement on this? It's 9 o'clock docket, sir. Here's the lady right here. This is her.
We need an announcement. We talked to the DA for a second. I can give you one.
Go ahead.
What's wrong?
Y'all, we're on YouTube. You don't want that kind of stuff on YouTube. That's just private stuff.
Judge not happy with the attorney showing up late. Judge Stevens is not the guy I'd want to make angry. That's for sure. One of the judges that we watch on a regular basis that I would not want to be on the business end of a lecture. That is for sure. All right, we'll see. We'll hang here with Judge Stevens for another minute or two because I want to see kind of how this goes, especially given Judge's current disposition. He does not seem happy with the situation. He wants to get to a trial. And of course, we won't be showing that trial here because we don't show long-form trials usually here on TCF Live, but we'll see how this resolves. We are, I think we're in the Wayback Machine here just a little bit, so we'll nudge this forward. There we go. And get back to Judge.
Let's get ready for trial at 9:30. Well, we're bringing the jury in. We'll bring the jury in at 9:30. We were in the course of deliberations.
During that day, so they call it that.
Thank you.
Oh. Well, I sort of thought we were going to get this resolved, but I just wanted to see what would happen with this attorney and all that. Well, I guess we'll have to come back to it. So in the meantime, we'll pivot here a little bit. Let's head back up to Michigan. We haven't, since I've been hosting, we haven't checked in with Judge Oakley. So let's do that. Let's see what's going on with Judge Oakley. We love Judge Oakley here on TCF.
How do you pronounce it? All right, I was pretty close. I understand you're pleading responsible to a parking ticket. We're going to dismiss a misdemeanor, correct? Is that a yes? Yeah. And you've agreed to pay $400? Can you pay it today? $200 today? When's the balance? Yes, sir. Tomorrow? You sure? You want to just pay it all tomorrow? By 3 p.m.? Doable? Okay, you're all set. Have a good day. Thank you. Taji Ali. Good morning, sir. Are you going forward today without benefit of a court-appointed attorney? All right, so we've got 3 tickets, 3 charges, I should say, from September 21. It says here you're going to plead responsible to a 4th charge, double parking. You've agreed to pay $380, and all 3 original ones will be dismissed. Is that correct? That's your agreement? We'll do it on a C. All right, and can you pay the $380 today? Next Friday? All right. I'll give you that as a due date. Understand if we don't get the money on time, then these other charges come back up and you got to deal with them. Any questions? Have a lovely day. Rebecca, is it Sowers? Come on up. Are you going forward today without benefit of a court-appointed attorney? And you made a deal. You're going to plead responsible to double parking. And you've agreed to pay fines the cost of $150, correct? Can you do it today? 3 p.m.? All right, you heard what I said about it. If it doesn't get paid, bad things happen. You're all set. You're welcome. Dylan, is it Humbarger? Good morning. Are you going forward today without benefit of a court-appointed attorney?
Yes, Your Honor.
You're asking for an adjournment to 12:04? Just have a seat right there. Just grab that chair right there. We'll get you a paper notice. We'll get you out of here as soon as we can. You're welcome so much. Shannon Phillips. Miss Phillips, are you going forward today without benefit of a court-appointed attorney? All right, and you want a jury trial on this? You understand the difference between a jury and a bench?
Yeah, the jury is the jury and the.
Yeah, so with a jury trial, I decide the legal questions, the jury decides the factual questions. Were you driving that day or were you not driving that day? With a bench trial, I decide both the legal questions and the factual questions. Understood? All right, the other thing is the jury trial is a longer process because there's a lot more people involved.
Yeah.
You understand that?
it's a long process.
Okay. Well, not here though.
Well, yeah,
Yeah.
here, when I very got, the citation.
Okay, hold on. This is only your second time here by my notes.
Well, yeah, but it's been going on since April.
Okay, but not here. No, you've only been here twice, right?
Well, yeah, but this has been.
Okay.
going on since April.
Okay, all right. So you want to have a jury trial or you want to have a bench trial?
I'm very sure.
And you're going to represent yourself,
I am,
having no idea what the court rules are?
yeah.
Okay, understand, I'm not taking you to law school for the jury trial. Okay? Give the lady a jury trial date. Angela, are you on?
Yes, Judge.
Heather wants to talk jury trial dates.
Okay,
The calendar, I need I think it's January.
I can,
January
Heather, come in.
22nd.
You want to come in?
Yep, because I'll be right in.
That's fine.
Calendar.
All right, Miss Phillips, we'll give you a couple dates in just a minute. You pick one, we'll give you a paper notice. Saeed, is it Mosin? Come on up, sir. Are you representing yourself today? No attorney? Okay. Is it all right with you if I dismiss this? Okay, you're all set. Case dismissed. You're welcome.
Reading some of those, I'm sorry, on the adjournments and the.
Oh, that's all right. We're getting through it. Ronald Fowler III. Good morning, sir. Oh, hold on. You've got Mr. Bowditch on your paper.
It's just a moving violation.
Are you okay doing it without Mr. Bowditch in here? Come on up. All right, with Mr. Bowditch's assistance, you worked out a deal with the prosecutor, yes? And you're going to plead responsible to a parking violation. You've agreed to pay fines and costs of $250? Is that what that says? All right, can you pay that today, sir? When? Calendar, if that helps. I can do some kind of payment thing, or we'll just get you a due date, whatever works.
6th of December. I was gonna send the January 6th.
I'm sorry, humbug.
No.
All right, you want 100 on what was the date?
6th.
And then the balance on February 6th?
Can we do February 6th? That'd be great.
I'll give you that long if that's what you want. I mean, you can always pay it off early. Yeah. All right. Do you need all that on paper or you got it? Okay, you're all set. Get out of here. Have a good day.
As well.
Oh, you probably already heard me say this. If the money doesn't get paid, then the misdemeanor's back up and you got to deal with that. Have a good day. We have a Stone Street.
I'm not going. We either. Ms. Phillips, we either have January 27th or January 29th. 29th is fine.
Yeah.
Yes, I do that.
Is that a HAFH?
I thought it was S.
Thank you.
Yeah. H. The first is cyan.
Yeah. Hashami? Hashami? How do you say it? Come on up.
I got it.
Morning, Trobus.
Morning,
What's your name, sir?
Certainly, that's it.
What's your name?
Farsi,
Karani? Raise your right hand. Arabic? Farsi. Do you swear or affirm that you will accurately translate between Farsi and English and Farsi so that we can discuss this matter today? All right, let Mr. Hashami know what we just talked about. I understand you're going to plead responsible to double parking today. And you've agreed to pay fines and costs of $400? And you're doing this without benefit of a court-appointed attorney? Okay, I'll accept your plea. Can you pay the $400 today, sir? How much can you pay today? Balance when? By November 12? Yes? Or December 12th, I'm sorry, by December 12th? Yeah.
Still copy the process.
Yeah, please. Yeah. Okay, any questions? All right, stick with me through the cashier if you would. Thank you, gentlemen. Have a good day.
From 25 years to life in Judge Stevens' court, and now to double parking. That's how it goes here on TCF Live. We're hanging with Judge Oakley for a few more minutes, and then got a lot of other places we can go as well as courts are online. And good morning, everybody. It's TCF Live, and more of Judge Oakley.
December 16th.
All right, is this final pretrial with complainant to appear? Or just final pretrial like we're not doing another pretrial? All right. Who's that with December 18th?
Us.
That's us? What time are you gonna do it?
8:30.
8:30 in the morning? To work? All right. Just have a seat. We'll get you paper notice. We working on this kid at the council table? Okay. We didn't forget you. We're working on your notice.
That was December 18th, right?
Good morning, Mr. Mays. You got one ready? Scratch the name on this one, would you? Yep. Gardner.
Scratch.
I'm ready on Gardner.
Good morning, Your Honor. William Mays on behalf of Mr. Brandon Gardner.
Good morning.
Correct, please. Judge, we're asking that this matter be adjourned to December 4th at 11 or thereafter. I've got a motion hearing that same day, same time, here in this court. But prior to that, I'll be in circuit. Mr. Gardner has received discovery videos and whatnot, but the prosecutor has unintentionally omitted some of these videos that are relevant and important, and she's agreed to get those to us.
Okay. Is that with us too?
What?
12:04. Time.
What is it for? Just
11.
Yeah, just a pretrial. You want to do it? Yeah, we can do it 11. He's got something else that scheduled.
It'll be at 9. Well, okay, that's fine. 11 for trial.
Yeah.
Yep.
Thank you very much.
All right, let's take care of our arraignment. Would you waive formal reading?
Pretend or not guilty.
All right. Any reason your guy is not a good personal bond risk?
No, no reason.
Would you tell me?
I'm sorry.
Would you tell me?
I would actually. He's got a prior in 23, and that's the difficulty with the circumstances.
Yeah. I'm going to put you on a personal bond with a couple conditions. The first two are pretty obvious. Number one, stay out of trouble. Number two, show up for court. All right. Third, do not purchase, possess, or consume any mood altering substance. That means no alcohol, no marijuana, and nothing unless you got a doctor's script. You got that? You can live with those rules. Raise your right hand for me. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you mess up on bond? Any questions? You're all set. We'll get you notice in just a minute. Have a good day, Mr. Mays. Anissa Thomas? Ms. Thomas, are you going forward today without benefit of a court-appointed attorney? All right, let's see what we got. All right, so we got one file from August 18, which is a drove while license suspended charge. We got 3 files from September 21, 2 civil infractions and a drove while license suspended. My understanding is you're going to plead guilty to no valid operator's license 2 times, and all of those original charges are dismissed. Is that your deal? Okay. Did you read your rights form? You understand all those? And do you understand the possible penalty for the charge of no valid operator's license on person? And understanding that charge, or the possible penalty, understanding your rights and options, are you pleading guilty freely and voluntarily 2 times today? All right. On those dates, August 18 and September 21, on each of those dates, were you driving in Van Buren Township? And on each of those dates, was your license suspended, revoked, or denied? I'll accept your plea to the added charges. I'll dismiss all 4 of the original charges in keeping with your agreement with the prosecutor's office. Ms. Thomas, are you working? Where do you work? How long have you been employed there? And what's the status of your record or your driving record now? Still suspended? What do you have to do to get right? When's the year up? So quite a while. Okay, all right. Is there anything else you want me to consider before I sentence you today? All right, I'm gonna have to lecture you. You can't afford to be a bad driver. Okay, and I'm sympathetic because I understand, number one, it's real expensive to get an Uber every day to go to work. And number two, we don't have real good buses in the area. But you can't keep driving like this because you'll never get your license back. And you'll keep driving because you gotta live, right? So oh, you owe us so much money. Give me an idea, this job, what kind of shift you work? And how many hours a week you're working? So it's only part-time? All right, you're local too. You're living in Belleville. All right. Anybody else you're responsible for? You got any kids? How old's your daughter? 4. All right. So she's not in school yet? She is? Okay. All right. So do you have time for another job?
Yeah.
When you go downstairs, I want you to ask Mr. Taylor, Avery Taylor, ask him if he knows of any jobs available, because he does. Because one of his job duties here is to keep track of area employers that are hiring. All right. So number 1, see what he's got. He might have something that's worth looking at. Number 2, he's also the guy you want to talk to about how you can get out from under this $4,000 debt with us, because it's going to take you forever to do it with greenbacks, right? Money, right? So we've got some options where you can do some work and some money and pay it off that way. All right. So there's payment options. All right, I'm gonna give you a Christmas present early. All right. I'm not gonna charge you any money or give you any work days on either one of these files because you're so deep into us right now. What I'm going to do is threaten the hell out of you, because I'm going to put you on probation for 12 months on each of these files. And the probation term is you stay out of trouble. That means if you get caught doing stupid driving while you're not licensed, I'm going to put you in jail. Okay? Is that a pretty good incentive for you to stop driving? I'm not going to wait for the money. You're already $4,100 into us. You can pay all this too. I'm putting you on probation. I'm still putting you on probation. because you got to stop driving. You'll never get out from under this. At least if you're going to drive illegally, drive better. They didn't stop you that day because you were suspended. What'd they stop you for? Understand, you're going to jail. You have to be better. Who's going to take care of that baby if you're in jail? Yeah, how happy is that going to make mom? All right, 12 months, stay out of trouble, no fines or costs, no illegal activity. That means a speeding ticket while your license is suspended is illegal activity. Go see Mr. Taylor and see if he can help you get out from under all this. Good luck.
Yeah, words to live by there. Judge Oakley. All right. It's the Courtroom Files Live. Thursday. Michael Groff filling in for Dan Soul. Thank you so much. He'll be back on Monday, so we're back here tomorrow morning as well. Tonight, once again, reminder, 8 p.m. East, 5 p.m. Pacific. Join us, won't you, for Sidebar. And should be an exciting evening talking about witnesses and sometimes how they can be your best asset, your biggest detriment, and all of that sort of thing. So that'll be tonight, again, 8 p.m. East, 5 p.m. Pacific for Sidebar. All right, let's head to Texas. Let's see what's going on with our continued commitment to give you 9 to 11% more Judge Boyd. So here is Judge Boyd.
Document entitled Motion to Revoke Community Supervision and First Amended Motion to Revoke Community Supervision with your attorney. Did you understand it?
Yes, ma'am.
Are you the same Lupe Colleen who was placed on community supervision in 2025 CR 0025568W for the offense of possession of a controlled substance penalty group 1, less than 1 gram, on February 27, 2025 for a term of 2 years? Is that you?
Yes, ma'am.
State.
Violate condition number 1 on or about the 24th day of October 2025 in Bear County, Texas. The defendant, Lupe Gregory Colleen, that committed the offense of possession of controlled substance in violation of condition number 1.
How do you plead to that? True or not true?
True.
Violated condition number 4 in Bear County, Texas. The defendant, Lupe Gregory Colleen, then and there failed to report to the supervision officer as directed for the months of August and September 2025 in violation of condition number 1. I'm sorry, 4.
4. Thank you. How do you plead to that? True or not true?
True.
State will waive the remaining.
Any objections to the state's waivers?
No objections, Your Honor.
Did you understand by pleading true to violations 1, 4, and 4, the court could find it true, grant the motion, sentence you up to 2 years in the state jail facility and up to a $1,000 fine?
Yes.
Knowing that, do you still wish to plead true to 1, 1, and 4?
Yes, ma'am.
Court will find 1, 1, and 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny state's motion of allow alteration to amend to include status with passive care.
That is correct, Your Honor.
All right. Do you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand. State your name for the record.
Lupe Gregory Colleen.
All right. So why is it that you didn't report?
In the process of being homeless and everything, it was the chaos in my head.
So why didn't you call probation and tell them what was happening with you?
And then corporation was one that didn't have money or anything that it was in service. I know we can use Wi-Fi and all that, but being homeless and living on the paperwork and the name of the probation officer and her number.
See, this is what you need to explain to me, and really this is something I want you to understand. You can't report to probation. You can't do certain things because all these obstacles are in your way, but you're able to find time to commit a new offense, which is the possession case. So you're able to find time to do that, but not report to probation. Here's the thing. They want you to do inpatient treatment. You know yourself better than I do, better than probation does, better than your attorney knows you, right? I'm going to give you a choice, right? I can deny the motion. You will go to inpatient treatment. You're going to wait for a bed. That program is 9 months, 6 months there, 3 months aftercare. Or I can revoke you and I'll sentence you to 18 months in the state jail facility. Do you need to discuss it with your attorney?
No, ma'am.
All right, so what do you prefer?
The set.
All right. Court will deny the motion. Alternate amend conditions. Is it safety? All right. SATA, and there is to be 30 sober support meetings upon release. And do you have any children?
Yes, I do.
Are they adults or no?
They're all adults.
Do you have grandchildren?
Yes, I do.
Are they adults?
No, ma'am.
All right. There's to be no unsupervised contact with minors. When's the last time were you were employed? I'm sorry, state, you may be excused.
It's been quite a while.
So how have you been supporting yourself, or have you not been supporting yourself?
I will go and donate.
I'm sorry, what?
I'd go donate plasma.
All right, so there's going to be proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. When you worked previously, what did you do?
I was working at it. Before I stopped working, I would work at a temp service for the temp service I was working at.
Okay, and how far did you go in school?
I did not graduate, but I do have my GED.
So what is if you could have a dream job, what's your passion? What would you like to do?
My passion would be to have my own company as in landscape.
All right, so there is going to be 80 hours of community service restitution. And if you get into landscaping and set up your own business for landscaping, I'll deem the community service hours satisfied. Otherwise, it gets hot in Texas. They'll have you picking up trash along the highways and byways. You understand?
Yes, ma'am.
And there's going to be regular random UAs upon release. Probation, is there anything else? All right, is there anything else you need from the court to be successful on this probation?
No.
All right, we can go off the record. Here's the thing, in this court, communication with probation is key to be successful. If you don't communicate with them, they don't know what's going on in your life. Sometimes people fall on hard times, but for you to just disappear is not a good thing. You understand?
Yes, ma'am.
If there's an issue, let probation know about it. If you feel as though they're not addressing it, you can always come back to the court. You understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
Thank you. Thank you, counsel. Yes.
All right. It is TCF Live. It is Thursday. Michael Groff here. All right. So we have a little bit of a situation over here at Studio B that I need to address very quickly. But before I do, Grandma TCF, Mama Joan, thank you for the $10 super sticker. Really do appreciate that. So I will explain what's going on here in just a few minutes, but I will have to be dealing with a little situation downstairs, and then I will be right back. But of course, I would never ever consider leaving you guys unattended necessarily. So of course, I will leave you in the capable hands of Judge Simpson. So We'll head out
That's
to
called the case.
Michigan.
People
Here's
versus
Judge Simpson.
Antonio Boswell.
And good morning, Your Honor. For the record, Terry Johnson, P70773, on behalf of Mr. Antonio Boswell, who was present and stands to my right.
Sir, can you state your name?
Antonio Boswell.
Thank you.
Oh, want to approach?
We can, Your Honor, may we approach?
He looks shady. Yeah, I know. All right. Yeah.
It's I'm a Spartan. He doesn't,
What?
I know I'm in enemy territory. I'm a Spartan, so you gotta.
You just don't know how bad the territory is. Just because I'm not a Wolverine.
Oh, I know.
Yeah, you should.
I know.
Okay. This may take a while because Spartan, so he has to talk. We have to talk slow. Come on.
Well, all right, never fails. I had no idea that was going to happen. Judge going private again. Judge Simpson likes to do that to us. I will apprise you of this situation here in just a moment. Well, let me just tell you what happened. So, our 15-year-old dog, Buddy, he is downstairs, and he made quite the mess downstairs. We'll just leave it at that.
All right, record should
and I will take care of that and then be back with you momentarily.
Request for an adjournment.
Hopefully, Judge doesn't go private again.
Will adjourn probable cause without objection to December 11, 2025, 9 a.m. Bond will at this point continue. All right. Thank you.
Thank you, Your Honor.
sir.
You're safe. Have a great day.
You do the same. Court calls case of the People versus Dave Knight.
Good morning, Rob J. going back, Mr. Knight.
Your name, sir?
Good morning, Your Honor. David Knight. Judge, in this matter, we'd like to set an exam.
Discovery is complete.
Yes.
We'll have their witnesses available the 8th.
Judge, I have a trial with Judge Kuhnke starting the 17th. Is it possible we can move this out? Or
I can set it the 18th. I can set it the 25th.
I know, but I can't be here on the 17th. I'll have somebody cover for me. Wait, let's do it the 17th, Judge.
The 18th, you mean?
I'm sorry, the 18th, yes. And may I address fine when appropriate?
Yes, you may. Let me set preliminary examination in this matter will be set for November 18th, 2025, 9 a.m. That is before Judge. I don't think so. That's before Judge Washington. All right. Chance to bond.
Judge, it's my understanding that my client is self-employed. He's a contractor. He unloads semis. He promises to prepare for all future court hearings. He would ask that if the court does release him, if it has to be, he agrees to a tether. He's in neglect court regarding his daughter. He would like to attend those hearings in person, and he's not a flight risk. Again, he would agree to a tether. And he's posted bond on his other matter. So he's asking if the court would allow a PR bond in this matter.
Response.
I would object to any reduction in bond. In this case, he was present with the victim and their child, and pulled the victim off because he had went through her phone and knew she was cheating on him. He then put his hand around her neck and strangled her, broke her phone, and was trying to prevent the victim from leaving the room with her child, for their child. I would object to any reduction in bond this time.
Was he on bond at the time of?
No, he
Other
had
matters
he had
at the time of
posted
this?
bond. I believe he had posted bond, right?
Yes, sir. Well, right, but he's,
I'm sorry,
but
yes.
he's on, bond. He had just posted when this allegedly occurred. Is that right?
Yes, Your Honor. He disputes what the prosecutors, what they're stating. But yes.
Understood, but he'll have a preliminary examination to have that looked at. Motion for bond reduction, given those circumstances, is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you. Thank you, sir. Court does call the case, People versus Thomas Gay.
Good morning, Your Honor. Christina Saxon for Thomas Gay, who's on my right. Mr. Gay, please state your name for the court.
Thomas Gay.
Requesting it, right?
Yes, Your Honor. I understand that there's a possible resolution. The prosecutor and I have spoken and possibly even resolve this before the next hearing.
Probable cause conference will then be adjourned to November 25th, 2025, 9 a.m. That's a Tuesday. Bond will continue.
Thank you.
Court calls case People versus Alicia Allen.
That's Phelps for the people.
Good morning, Your Honor.
Morning.
Assistant Public Defender Brian Bowling on behalf of Miss Allen. Can you state your name for the record?
I'm Alicia Allen.
Your Honor, we're asking that this matter be set for an exam. All discovery is complete to my knowledge.
And would the people have their witnesses available the 18th?
We can direct my data.
Preliminary examination in person will be set for November 18th, 2025. 9 a.m. That is before Judge Moore.
Thank you, Your Honor.
Thank you. Bond continue.
Your Honor, may I address one issue of bond?
You may.
It's my understanding that the last time Miss Allen was before you, denied the request for her to be released to treatment. If it became available, I'd just ask you to reconsider that.
And Your Honor, I'm sure the court recalls when we were here before, I let the court know about my concern, any change in her treatment, any change in her bond rather, at least the treatment, which is extremely unusual, but given the fact that this case, she was driving down 94, hitting more, I believe she hit at least one car, if not two cars, and this is an OWI third offense with a child as well in the vehicle. So I'm very concerned about her getting out at all this time.
And has treatment been arranged at all, or?
I don't believe so, Judge. There are other holds that you need to address as well. Just if it became available, we'd like to have her be able to have that opportunity to go into that program.
I mean, certainly if there were treatment available, I'm not going to have a problem. I mean, I have some issues. It's more the manner in which, I don't have a problem with the treatment. I have a problem with the manner in which she's released, making sure that we have enough safeguards and controls regarding her.
Okay.
So at this time, what I'll do is I'll again deny the request. But if you come up with something, certainly get it to the court and I'll be happy to take a look at it.
Will do. Thank you.
All right. Thank you.
Thank you, Your Honor.
Thank you. Court calls case People versus Larry Atkins. Or Larry. It's Larry. That's right. It's Larry. It's Larry that people messed up. I'm looking at it, I said, I know it's supposed to be. Man, I'm sorry. Go ahead.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Atkins. Will you state your name for the record?
Larry Atkins. Yes, I know. Okay.
Your Honor, we did finalize a mitigation report that's been provided to the people. They just need an opportunity to review that. Could have an adjournment.
Probable cause conference will be adjourned until November 25th, 2025, 9 a.m. That is a Tuesday. Bond will continue. Okay.
Yeah. Okay.
Court does call the case, People versus Robert Arnett. Three cases.
Assistant Public Defender Sandra White on behalf of Robert Barnett.
Your name, sir? Robert McCorn.
And Your Honor, we were here before and we have identified that two of these cases are duplicates, so it's going to be only filed. I'll have the case number for you here in just a moment. I apologize for the delay. But other than that, I think we are really looking at an adjournment for today's matters.
That is correct, Your Honor. We are asking for an adjournment on one of the cases, 25 F5 5793. We are still looking for media on that case.
On 5793.
Yes, we're still asking for body cams or any available videos.
Okay.
And the other one, I have two case numbers because I'm not sure which one is going to be dismissed.
Right. No, I got you. So, but you're ultimately looking for an adjournment on both of the ones that remain.
That's correct, Your Honor. And if I may address bond?
Hang on one moment. Let me make sure my paperwork is right. So probable cause conference in this case will be adjourned to the 20th. November 20th, 2025 at 9 a.m. Bond will, well, yes, I'll address bond in a moment. I just want to get one that's going to be dismissed all set. Is it gonna really matter?
Ultimately, I think it's going to be the. Oh my gosh, what am I think it will end up being the 24FB1406.
That will be dismissed?
Yes.
Okay.
But I believe that one, it will be on the paper, but I do think it will be that case.
The 1406?
Yes.
Okay. And I'm assuming there's no objection to the dismissal?
No, Your Honor.
Right, so
No objection.
I'll mark that one as is. If there's some reason that's not it, then we'll deal with that. All right. And then the other case, I will adjourn to that same date of November 20th.
Thank you, Your Honor.
And then as to bond.
Yes, Your Honor, I do believe it was addressed at the last hearing, but Mr. Barnett wants this court to know that he will abide by all bond conditions. I believe one case is over a year old, and he was an addict at that time. He is currently doing Dawn Farms. He's doing it very successfully. He wishes to continue his treatment outside. If he cannot have a PR bond or home confinement tether, he wants to be released for treatment.
And I do think he was in bench warrant status at the time of the 2025 case.
Yes, he was.
That's my objection at the last 5 years.
And that is my same objection. And he was in bench warrant status for a period in time. So I'm gonna, again, deny the request for a bond modification in this matter. Bond will continue. Thank you.
All right.
Well, Your
Bond will continue. All right. Thank you, Judge. Michael Groff back here, TCF Live. Okay, yes, to reiterate, apologies there. I had to be out of the studio for a few minutes. Our 15-year-old dog buddy made quite a mess downstairs, pooping and stuff. And I didn't want to wait till the end of the show to deal with that. So, yes, there we go. That's all taken care of. We're back. We're good. All right, going to take a deep breath. Let's go someplace we don't go too terribly often. Let's go to Fulton County State Court and see what's happening over there this morning. Or not. All right. So we We don't have audio. We're turning a Thursday into a Monday. Okay. Let me fix that. Okay.
And giving false information. You also have 25 CR 005300H. In that case, you're charged with theft by shoplifting and conspiracy to commit a misdemeanor. You have a right to remain silent. You have a right to counsel. And as you can see, I'm conducting this hearing by video. Do you understand all of that today? All right. So the offer is diversion. So I'm assuming what is going to have to happen is he needs to get a signature bond through pretrial services. Is
Yes.
that correct? Ms. Spears, is that your understanding of the situation?
Yes, that's correct, Your Honor.
Okay, so what is his current bond? Does anyone know?
It's been admitted, I regret.
That's okay. We're gonna see if we can look it up.
I'm looking, Your Honor. The computer's just moving slow. Hold
I
on.
know mine too. I didn't even bother.
On count one, his bond is 1,000 good.
Is 1,000 good total on that case or just the first charge?
Taylor downstairs.
No, let me see. Let me open it.
Cause he got 4 charges.
I know. So from 9-6, they said 1,000 good. I'm looking at the bond order now.
Did I sign it?
It's coming. It's coming.
Can I say something?
It was $250 per charge, and yes, ma'am, you did sign it.
Okay. All right. So we're gonna convert on count one. I'm sorry, in case one ending in 5299H, defendant's good bond is gonna convert to an SOB through pretrial at level if I get it good, level 2. Okay, and with the same requirements. I'm sure there was, what was it, Ms. Young? Was it stay away from where?
It would have been Lennox.
Lennox Square.
Okay.
Yes, ma'am, Lennox Mall, the entire mall.
Okay, and on the case ending in 300H, I'm assuming he has a similar bond.
It's coming up now. Hold on.
Okay.
It's 1,000 good. Yes, ma'am. He has a similar bond, so $250 a piece.
Okay, so it's gonna be I'll convert that one also to 1,000 SOB through pretrial at level 2. He'll be reset for the notice for compliance with that diversion at a division judge. Is there anything additional, Mr. Murphy or Ms. Spear?
No, Your Honor. Thank you.
All right, Mr. Avery, you're getting a signature bond. Don't go back to those locations. Make sure you comply with all the diversion requirements, and another judge will see you to check to make sure you've met the requirements of the program, okay?
Thank you. Thank you.
All right, best of luck to you. Take care. Don't go back to either of those places, all right?
Yes, ma'am.
All right, take care. Have a good afternoon. All right, who else was at South Annex, or is that, all right, South Annex complete?
I have a Travis Buford.
Is Mr. Murphy gone?
Murphy alone.
Oh, he's gone.
No, it says he's always under iPhone.
Yeah, Mr. Murphy, are you still there with us? Can you hear us?
His video now. He'll probably be right back.
Yes, I hear you now.
All right, Mr. Buford, is that your client too?
That is correct. And Judge, as it regards to Mr. Avery, he's 17 now. Was he going to need the mother to come on in on that signature bond?
Sure. What's his mother's name?
I do. I'll have to. He might have been on the call, Judge. Apologies. I can relay that to the clerk.
Okay, then that'll be fine. And his mom will be the co-signer.
Okay. Yeah.
All right, so that's fine.
All right. And then Judge, you're right. I have Mr. Bufford.
Oh, I'm sorry, I'm saying it wrong. Okay, so do you have an announcement for that case, Mr. Murphy?
Yes, Judge. He wants to go to the division judge. However, he currently has.
I lost you for a
Judge,
moment there, Mr. Murphy. I'm sorry. What were you saying?
He currently has $250 bond on each charge. So I think it's $2,250. Judge, I would ask the court to just, if we could set that at a say a $35 cash bond. He already has two other bonds that have been made by his girlfriend and family, and they say they really have no other resources at this point. And I know the court would be reluctant to give us a sign-on bond if they would consider that. But I was in the alternative, perhaps something along the neighborhood of say a $35 cash bond, $5 on each charge, if the court would consider it.
Okay, so we'll have to hear this whole case on bond. All right, Mr. Buford, your case is 25 CR 006061B. You're charged with 2 counts of escape, 3 counts of interference with property, 1 count of simple battery, and 1 count of theft by taking. Can I have his history, Ms. Washington? I think I set this bond, but let's see.
Your
Miss-
Honor, you did set the bond and it's $1,750. It was $250 on each charge.
Okay, I vaguely remember this case. But I still need to hear the history though, if you don't mind, Ms. Washington, when you have a moment.
Yes, Your Honor. There are 30 arrest cycles. The last arrest appeared to be from September 19th of this year for a probation violation. There appeared to be an arrest in May of this year for theft by shoplifting felony, possession of a firearm by, possession of a firearm during, and theft by shoplifting. A second count felony. Also in 2024, there was a felony conviction for possession of a firearm during and 2 counts of aggravated assault. There was an arrest in 2020 for simple battery family violence that appeared to be dismissed. 2019, a misdemeanor conviction for driving without a valid license. Probation violation arrest in 2017. 2018, misdemeanor conviction for criminal trespass. There was also an FTA in 2016. A misdemeanor for driving without a valid license, also in 2016. A battery family violence in 2016 out of Fulton County. And nothing further, Your Honor.
And that's not an ideal history there. Ms. Spear?
Yes, Your Honor. We would ask if the bond would stay the same at this time. As Your Honor is probably aware, as you heard this before, that Mr. Bufford has 2 charges of escape for tampering with the sliding doors. He and 2 other inmates made it a point to escape to beat up another inmate. They then robbed the officer from zone 700. They took his food that he had purchased from the jail's cafe. All this was caught on tape. Due to his history, the deliberate intention to escape, and in order to do so, interfering with government property, in order to attack another inmate, we feel the bond is more than generous at this point.
All right, and Ms. Murphy, what was your ask? Sir, don't say anything. The best thing for you to do is let Mr. Murphy speak for you. Mr. Murphy, you still here?
He's here, Your Honor. He just might have him, he sits out in the hall, so he should be on in a moment.
All right, I'm sorry, Mr. Murphy. And what was you're back with us. What was your ask?
Judge, I was asking for just a cash bond, say, reasonable cash bond, say $5 on each count, $35 cash.
Can't do that, Mr. Murphy.
Yes, Judge,
Okay.
I had to ask.
He's been in custody since May. He was picked up in DeKalb. They made bond, but unfortunately there was a probation hold, so he was shipped out, and he's been in custody since. And that's what we wanted to address, because he says the tape regarding this jail incident would exonerate him, and so therefore he says he's not guilty of anything. So, all right, Judge, we'll just send it to the division judge, and I appreciate it. I'll take up that.
He's trying to say, sir, I think you should let Mr. Murphy speak for you. Do you have a question about the bond? Please don't say anything to incriminate yourself. The state is listening. What is your question?
On the plea that was on, I'm just ready to go ahead and take the plea. The plea that they was trying to give me last week, I'm just ready to go ahead and take it. I'm trying to get back to my children.
Judge, if I can call the South Annex, so they'll call me. I'll talk to him if he wants to do that.
Okay, that's fine. And there was a plea offer. Would taking a plea to this charge, does he have other holds, Mr. Murphy? Because you just mentioned a probation hold.
We thought there was going to be a probation hearing on the 30th of last month, and I'm not sure if that took place.
Done with probation. I just got done with them. They gave me time served. I'm done with probation.
Okay, Judge. Okay, that was news to me, because the family said that they were unclear as to that. So
I'll let you speak to him, and we'll come back to this case.
Thank you, Judge.
Okay. All right. Thank you. All right. Who is that? ACD? I'm sorry. Go ahead, Ms. Young.
Your Honor, Miss Avery is on the line. She was Mr. Avery's mother.
Okay, all we need is her name, and then she's free to go.
Okay, I have her name, Lakeisha.
Okay, all right.
Thank you.
All right, who is that? ACDC?
Hi, Your Honor. I have positions 40 and 46.
I don't know that. Mr. Haddad, are any of those yours?
Yes, Judge. I think they are, Judge. And I'm ready. They're negotiable pleas. I have a third individual as well on ACDC for a plea.
Okay, hold on.
Mr. Haddad, Ms. Heron was released last night.
Okay. All right, man. I'll talk to the ASG on that case.
Hold on 1 second. Let me get myself a little bit more organized. All right.
I didn't hear who they said was released last night.
Position 23.
Thank you.
Chloe Heron.
Thank
Yeah,
you.
she was extradited to Mississippi. She had signed the waiver, and I was hoping we'd be able to resolve the case, but alas, unless the state wants to not process.
Released. That was 23. Okay.
Your Honor, position 47, Miss Woodard, she came to our office at pretrial, and we provided her with the Zoom link, and I just wanted to let you know I think she's on here.
Okay, thank you.
You're welcome.
All right. Let's go back. Who is that? ACDC?
Position 40 and 46.
Okay. So let's do 40 first. And all defendants, please pay attention. Good morning. This is State All Purpose Calendar in the State Court of Fulton County, Georgia. I'm Judge Melanie Williams, and at this calendar, we will address matters for those individuals who are currently incarcerated in the Fulton County Jail. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have the right to an attorney today. And as you can see, I'm conducting this hearing by video. When I ask if you understand your rights, that is what I'm referring to. You are Miss Triplett. All right. Your case is 22 CR 002184J. In this case, you're charged with giving false information. Do you understand your rights this morning? All right, thank you. Ms. Spear.
This is my
I'm
case,
sorry,
Judge.
Mrs. Sirocco, please proceed.
No worries. On the giving false information to law enforcement, the state's recommendation here is time served, 26 days. We would ask the defense stipulate the factual basis, venue, and ID for purposes of the plea.
And so do you so stipulate, Mr. Haddad, and that was your understanding?
It is, Judge. We stipulate. Thank you.
All right, thank you. Ms. Triplett, we need you to scoot closer to the microphone. We're gonna have to be able to hear you. I can see what you're saying, but we need to hear you for the purposes of of taking a plea this morning, okay? Please raise your right hand and speak as loudly as you can. Do you swear or affirm the testimony you give today be the truth to the best of your knowledge and is given to us under the penalty of perjury? All right, I still can't hear you. And I don't think the court reporter can either. Is there someone at ACDC that can help us with the microphone, perhaps? Because I could hear earlier, but we can't hear you. Try to say something now, Miss Triplett.
Yes, ma'am.
Okay, that's perfect. Thank you. Speak just, and you can put your hand down. Thank you. Are you under the influence of any drugs or alcohol at this time? Speak, come back over where you were because we couldn't hear that. Say that again. Perfect. Did anyone force you to take a plea today? Can't hear you again.
Oh, ma'am.
Perfect. Thank you. And are you satisfied with your attorney's representation?
Yes, ma'am.
Thank you. And do you understand that taking a guilty plea, you're giving up your right to trial by judge or jury? And you're giving this guilty plea freely and voluntarily today? All right. As to the charge of giving false name, how do you plead, Ms. Triplett? I accept your guilty plea. Is there anything additional from the state or from the defense?
Nothing from the state, Judge. Thank you.
All right. That'll conclude your case for today. Best of luck to you, ma'am. All right. All right, Miss
Barbara, thank you for the gifted membership. Really do appreciate that. Helps out the channel, helps out Dan, helps out everybody. Again, it's a great community. I thank you guys so much for all of your continued support. And while Dan is on vacation, all these super chats and super stickers, they do go to me. But the all the channel memberships and all that, of course, that goes to Dan, that goes to the channel, that goes to Ellie, that goes to his rabbits, that goes to everybody over there. So really do appreciate that. All right. Let's see. I think we've got everything kind of fixed up here. Let's go to Texas. Say good morning to Judge Rubber Gloves. You know, it's been a while since we've checked in with him, see what misdemeanor hijinks are ongoing in Jefferson County. If see what he's got going on here. Fulton County was having audio issues. He's having
Number 2 is in session. The court is in session in cause number 25 CCCR 0010. Case is filed in the state of Texas versus Gerald Wayne Talley. Mr. Talley, is that your full name?
Yes, sir.
Mr. Talley, would you please raise your right hand? Mr. Talley, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Talley, you may put your hand down. How are you doing, Mr. Talley?
Yeah, pretty good, sir.
That's good. And Mr. Talley, you're represented in your case by your attorney, Attorney Mark Provo. Ms. Provo, how are you doing?
I'm doing fine, man.
And Ms. Provo, do you waive a record in Mr. Talley's case?
We do.
State is represented in this case by Attorney Shane Hilton. Mr. Hilton, how are you doing?
I'm good, Your Honor. Thank you.
You're welcome. Now, Mr. Talley,
Yes, sir.
I have before me on my computer a document that is titled information. This information is filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Gerald Wayne Talley, on or about November 13th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest detention. Mr. Talley, do you understand what you have been charged with?
Yes.
To this charge, how do you plead guilty, not guilty, no contest? Now you're pleading guilty freely and voluntarily. Now, Mr. Talley, I'm looking at a document. It seems to have some initials on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document that's titled no contest? So you pleaded no contest?
Yes, yes, sir. I mean,
And Mr. Talley, Are you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Okay. Now, Mr. Talley, I also have a document before me that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
Now, Mr. Talley, on page 2 of the same document, these are a set of initials that I just showed you. On the line next to boxes checked, no contingent, which means no contest. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Mr. Talley, I also have a document on paper that is titled Misdemeanor Plea Admonishments. That's titled Discovery Certification. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant? Now, Mr. Talley, before you sign and initial all of the documents that I just showed you, did your attorney, Ms. Provo, go over these documents with you?
Yes, sir.
Did you understand everything that Ms. Provo went over? Is everything in these documents true and correct to the best of your knowledge? Mr. Talley, are you a citizen of the United States?
Yes, sir.
Cover States Exhibit 1.
Any objection? No objection. States Exhibit No. 1 will be admitted. Ms. Provo, you've advised and counseled Mr. Talley. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Talley, your attorney, Ms. Provo, has advised and counseled. I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that do we have a plea bargain agreement?
Yes, we do, Your Honor.
And what is that agreement?
Your Honor, we'd ask the court for 86 days county jail with credit for time served of 86 days. And ask that the court costs in this matter be taxed and retired.
Okay, Mr. Talley, the state is offering that you serve 86 days in Jefferson County Jail, but you will not be required to serve any more time in the Jefferson County Jail in this case because you've already served 86 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. It simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court cost. Therefore, the court costs will be taxed and retired. Mr. Talley, do you understand the state's offer? And do you think that the state's offer in your case is fair and just? And do you accept the state's offer?
Yes, sir.
Mr. Talley, I'll follow the plea bargain agreement that you have entered into with the state. Now, Mr. Talley, if there is not anything else holding you in jail, you'll be getting out of jail today. And Mr. Talley, you're going to stand at the end of that table, follow the directions of the bailiff. Once you finish following the directions of the bailiff, you can follow the bailiff and you have a blessed day.
Okay, you too.
Thank you. Soraya Smith. No, Soraya Reggie. Soraya Reggie.
Yes, yes, sir.
Okay, Soraya Reggie.
This is Sam.
Yeah, I don't know.
Yeah, sorry. Yeah. I don't know, I must have saw Smith.
Yeah,
Reggie. Soraya Reggie.
Did we hear from John?
Yeah.
They was gonna try to get him to call.
Okay, this is cause number 24 CCCR 2738 and cause number 24 CCCR 2742. Both cases are styled the state of Texas versus Soraya Reggie. Ms. Reggie, is that your full name? Ms. Reggie, would you please raise your right hand? Ms. Reggie, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. Reggie, you may put your hand out. How are you doing, Ms. Reggie?
How are you?
I'm doing fine, thanks for asking. Ms. Reggie, you're representing your case by your attorney, Attorney Marvin Provo. Ms. Provo, do you waive a record in Ms. Reggie's cases?
We do, Your Honor.
Ms. Reggie, In cause number 24 CCCR 2738, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Sarai Reggie, on or about September 30th of 2024, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of evading arrest, detention. Ms. Reggie, do you understand what you have been charged with?
Yes, sir.
To this charge, Ms. Reggie, how do you plead guilty, not guilty, no contest? Now, you pleading no contest freely and voluntarily?
Yes, sir.
And are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means. Now, Ms. Reggie, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. Do you recognize this document?
Yes, sir.
Now, this document is also labeled as State's Exhibit Number 1. On page 2 of this document, you didn't check the box. She put initials, but the box isn't checked.
Okay.
You just have to check the box. Now, Ms. Reggie, the document that you're signing on page 2, it has initials SR next to a box that's checked, null or continuing, which means no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of the same document, there's a signature above the line that's titled Defendant, is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right to appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to appeal, which means you're giving up your right to appeal. Do you understand that statement? I also have a document on paper that is titled Discovery Certification. And do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant? Ms. Reggie, before you signed and initialed all of these documents that I just showed you, did your attorney, Ms. Provo, go over these documents with you?
Yes, sir.
Did you understand everything that Ms. Provo went over?
Yes, sir.
Is everything in these documents true and correct
Yes,
to the best of your knowledge? Ms. Reggie, are you a citizen of the United States?
State Officer States Exhibit 1.
No, thank you.
No objection, States Exhibit Number 1 will be admitted. Ms. Provo, you've advised and counseled Ms. Reggie. Is there any evidence that she is currently mentally incompetent to stand trial?
No, yeah.
And Ms. Reggie, your attorney, Ms. Provo, has advised and counseled you. Are you satisfied with her representation?
Yes, sir.
Has she provided full, effective, and competent legal representation?
Yes, sir.
Okay, Ms. Reggie, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor. We'd ask the court for 23 days county jail with credit for time served of 23 days. And that's if the court costs in this matter be taxed and retired.
And 23. Good. So. Okay, Ms. Reggie, the state is offering that you serve 23 days in Jefferson County Jail, but you would not be required to serve any time in the Jefferson County Jail, any more time in the Jefferson County Jail on this case, because you've already served 23 days in Jefferson County Jail. Therefore, you'll be given credit for the time that you've already served. The court costs in this case will be taxed and retired. That simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid off the court costs. Therefore, the court costs will be taxed and retired. Ms. Reggie, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes, sir.
Ms. Reggie, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Reggie, I'll move on to your next case. Mr. Reggie, your next case is cause number 24 CCCR 2742. And in this case, Ms. Reggie, I have before me a document that is titled Information. And in this information, Ms. Reggie, it alleges that you, Soraya Reggie, on or about September 30th of 2024, while you were in Jefferson County, Texas, that you committed to Class A offense of resisting arrest. Ms. Reggie, do you understand what you've been charged with?
Yes, sir.
And to this charge, Mr. Reggie, how do you plead guilty, not guilty, or no contest?
No content.
Are you pleading no contest in this case freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
We still have audio. It's just Judge Rubber Gloves here. Judge Holmes is reviewing
Miss
documents.
Reggie. Okay. Resisting arrest, is that correct?
Yes, sir.
And state your office number one.
We haven't, Your Honor, but the state will offer it.
Any objections?
No objection.
No objection. State's exhibit number one will be admitted. Now, Ms. Reggie, I also have before me, well, actually, state's exhibit number one, it has, do you recognize this document?
Yes, sir.
And on this document, it has your initials on second line. Is that correct?
Yes, sir.
No contender, which means no contest, and your signature on page 3. And on the next document, chocolate certification, this is your signature.
Yes, sir.
And 2 boxes of check. First box states that this is a plea bargain in case you have no right of appeal. Second box states that you're waiving right to appeal. You understand that?
Yes.
And I also have before me the discovery certification. Is this your signature?
Yes, sir.
Now, before you sign and initial these documents, your attorney went over these documents with you, right?
Yes, sir.
All right. Now, Ms. Provo, you've advised in counsel, well,
Right.
yeah, you already stated that she's mentally competent to stand trial. So, Ms. Reggie, I will accept your plea of no contest. I will find that you're mentally competent to stand trial. I also find that your plea and waivers were freely and voluntarily given. I also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, we do, Your Honor. We asked the court for 23 days county jail with credit for time served of 23 days and asked that the court costs be taxed and retired.
Okay, Ms. Reggie, the state is offering that you serve 22 days in Jefferson County Jail. You would not have to serve any more time in Jefferson County Jail in this case because you've already served 23 days in Jefferson County Jail. Therefore, you're given credit for the time that you've already served. The court costs in this case will be taxed and retired, which means that you would not have to pay it because the time you spent in jail has already paid off the court costs. Now, Ms. Reggie, if you do not have anything else on you in jail, you should be getting out of jail today. You're gonna stand. Now, Ms. Reggie, you understand the state's offer?
Yes, sir.
You think that the state's offer in your case is fair and just? Do you accept the state's offer? Okay, I'll follow plea bargain agreement that you've entered into with the state. Please stand next to the bailiff. Follow her direction. Once you finish following her directions, you can follow the bailiff and you have a blessed day.
All right. It's TCF Live. Thank you for joining me. Really do appreciate it. Hanging out in the chat with us, all of that. We really do appreciate it. Tonight, 8 p.m. East, 5 p.m. Pacific, it'll be Sidebar. And that's our evening, that's our, well, twice weekly show. We didn't have one on Tuesday, though, because of other scheduling issues. But nevertheless, we do that usually twice a week. So tonight, be sure to join us for that. It should be an exciting show. Of course, Dan will not be here, but he will be back next week. And we can't wait to have Dan back here. And I'm sure you guys can't wait for that either. All right, let's head up to Wisconsin. Let's say hello to Judge Mulligan, everybody. And we don't have audio again. It's been that kind of a day.
Matter be adjourned to a different date. You wanted to state reasons, Ms. Thomas Schmidt?
Your Honor, this is a modification of support order request, actually. And Mr. Merrill, when we filed the request, was in custody on a probation hold in Polk. We were told he would be revoked, would be sitting a long time. So we filed the request to modify based on his proposed inability to pay. That probation hold since been resolved. We've been told he's going to treatment for approximately 30 to 45 days once his commitment order in Burnett County is resolved, which is up for hearing November 17th. So we would like to see what happens there.
I'm doing it right now.
Oh, okay.
Sorry, I found out about it from Mary this morning, and I thought, why wait? Let's just address it all. Well, we have them here.
Okay.
You're here. One fell swoop.
Okay. I guess if he's going to remain in custody for a lengthy period of time, we would be seeking to temporarily suspend the order. If he's going to be released from custody in a relatively short period of time, we would want to review in a few months to see if he's going to be staying in the area or not.
All right, thank you. Mr. Merrill, do you understand you have the right to an attorney?
Yes, I do, and my last name is pronounced Merle.
Oh, I'm sorry, Merle. All right, Mr. Merle, do you understand that you have the right to an attorney?
Yes, I do.
And you would have the right to call witnesses, testify, or remain silent, but in a case like this, it can be used against you. Do you understand that?
Yes, I do.
All right, so today we're going to address two things. Well, first, I'm going to move on to this forfeiture matter. This is a very old case. It's 14 CM 132. All right, 14 CM 132. And it shows that you owe $1,293 in past fines and fees and restitution that's owed. Is this the case that involves a cell phone or something? Very old case, and I can't remember off the top of my head. Do you remember what that restitution is for?
Yes, it is for a cell phone.
I thought I had looked into this at some time. Okay, it is for a cell phone. Oh, yep, for victim AMA. Unfortunately, with restitution, this is not something that the court can waive or that the court can make disappear because it's restitution and it's owed to a victim. The only way that restitution can go away is if it's paid off in full or if there's an agreement reached by the victim, okay? I don't even know where AMA is today because this is an 11-year-old case. So, Mr. Merrill, if I'm recalling correctly, and I can look at my records, you were here, yes, it was a year ago, almost to the day, a year ago, that you were in front of the court and we acknowledged this and you were going to start to pay $50 a month. But then I'm going to tell you, I didn't even receive one payment, not one payment. Why not?
Yes, sir. I wrote a couple of letters to you personally and to explain that Polk County with the open case, I was qualifying for some programs through the St. Croix.
Oh, I understand that, but that's like so low on my list right now. Don't care about that right now. I'll deal with that later.
No.
What I
Okay.
care about is why I didn't get a payment for a whole year. That's what I care about.
Because I didn't have no income coming in. I struggled with homelessness again after I completed my program, and because of the open case, I didn't qualify for the program. Now I do qualify for it because we
But
did
again,
resolve our problem. Yeah, I understand. I
Again.
apologize extremely. I do.
No,
but
no
I do-
apologies. I don't accept the apologies. They don't
Yeah,
exist.
Okay.
They're not real. They're not real
Yes.
because I didn't hear anything from you until you were in custody in Polk for whatever you're in custody in Polk for, okay? I heard nothing. I didn't hear, dear judge, I'm having a difficult time right now. I'm not able to find work. I'm not doing blah, blah, blah.
Yes,
I
I
received-
understand. Yes, I understand that. I did write you once at 326 to let you know what was going on with my treatment programs and to let you know that I would be, but then the whole thing got in turmoil where I could not, find work like you just said, and but I do have a check from the Red Lake Nation coming in within the month here, and that's the only income that I've had coming.
How much is
I
that?
understand that. I understand that I was to keep in contact with you, but I just with the troubles of
I'm hearing
homelessness
excuses.
and-
Just stop. I just keep
Okay,
hearing
thank you.
excuses
Okay.
and I'm done with excuses.
Okay.
What I want to know is what I want to know, okay?
Okay.
I did receive a letter from you in March of 2025, and it said that you were transferred from Burnett County Jail after I was very lenient with you and released you, and you went to Polk County Jail to, again, do whatever you have going on in there with probation. I'm going to guess it's the same probation you're here right now. And then in there, you said you sat until December 31st. Okay. Again, doesn't affect me and my payment and why I didn't get a payment. And that was an alternative to revocation. So obviously you weren't doing what you needed to do on probation. You just weren't. And then it said you were placed at the healing center. Great. I like that program. It's excellent. It's wonderful. I truly like that program and what it does for our community. All right. But then that was your final phase, and you said that, and you were scheduled to graduate as of May 27th, 2025, okay? After that, I heard nothing, not one peep until whoopsie doopsie, back in Polk County Jail. You might be in my jail now, but you were in Polk County Jail with probation, some violation or whatever's going on, another ATR, and you can go to treatment again. That's from a new letter that you've sent to me, but nothing. And what you said in there, and I believe I granted it, what you said in your March letter is, can we lower my payment from $50 a month to $25? 50 to 25, okay? Yep.
Yes, I remember.
Court agreed, right? I said, sure, we can do that
yes.
until you can get on your feet. But then after March, until you were in custody again, did I receive $25 payments at all? Did I?
No, you didn't.
And did I receive any communication until you were in custody again?
No, but I was in another treatment program in Duluth.
I don't care about that. Again, don't
Okay.
care. My question is, did I receive communication from you after March 18th, 2025?
No, you didn't.
So I didn't receive a payment at all, not one, nor did I receive any update. Nothing. Not even, hey, I'm in treatment again, or I'm doing this, or I'm doing that, or I'm doing whatever. Nothing, right?
That's what my the letter I wrote to you in March stated, that I was in a treatment program.
Right, and I read that. I did. The Angie Biz, I can't even say it. I want to learn how to say that. The healing center. All right. Yes, I got that. But I'm saying after March.
No, after
right?
March, where I was writing to you from after the healing center. No, after the healing
You're
center,
not listening. You're not listening. You're not listening. Please answer my questions.
Okay.
After March 18th, 2025, after that date and time, but prior to you becoming in custody again, okay? So between March 18th, 2025, until you just recently got in custody again, did I receive any letters from you?
I wrote one to you, and I got a response from your clerk of court, Jacqueline, and she said that you agreed to wait until I finished the medium program that I was in Thunderbird Ren.
That
And
was
that's
after your March letter. That was after your March letter. That's what I'm saying. After your March letter, and I didn't agree to stay on anything. I never agreed to stay on anything. What I'm saying is, please understand and listen.
Yes.
After the March, or after, I'm looking at that March letter, okay? March 24, 2025 is when it was received here, but you wrote it March 18, 2025. After that letter, okay? Until you were in custody again, did I receive a payment? You said no. Did I receive any other letter from you since March 2025 until you were just in custody again and asked for another favor?
No.
Thank you. Exactly what, that's exactly what the facts state and show, okay?
Yes.
I've got nothing from you since 2014 or when you were convicted here. And I don't know your conviction date, but right here I can go judgment of conviction, November 2nd, 2015. Very, very little payment. And since I've been on the case, no payment, okay? None. And we had a payment agreement for a whole year, nothing. Even when you tried to renegotiate the terms of the agreement you reached with the court to modify from $50 a month to $25 a month, and the court granted it, not one payment, and then no further communication until you needed something or wanted something, right?
I'm not understanding.
Until you were in custody and said, please judge, please, judge, please, I want to go do what I want to do, more treatment or something, right?
Yes.
Exactly. All right. So you're receiving a check this month, right? Correct?
Yes.
When are you receiving that check?
I wrote a letter to the Red Lake Nation. I waiting. It's getting sent to my brother's house in Danbury, so I have not spoken to him because he doesn't accept calls from this jail.
All right. So how much is the check supposed to be?
$250.
$250. But you don't know when it's supposed to come, right?
They said tentatively between right after Thanksgiving is what they said on the website.
What they said on the website?
Yeah, there's the resignation. They call it trust fund, says they went into a new business adventure, and they're granting us $250 check. You know, after the Thanksgiving, somewhere around Thanksgiving, to be mailed, and
Okay.
I got to go into my brother's house.
Well, or your brother has to bring it to you and sign it and get it cashed and have it paid over, right?
I was just gonna sign it over to Bridget County, but yeah, yes.
I don't know if we can take a signed over check. We cannot take a signed over check. It'd have to be signed. Somebody would have to cash it. They'd have to bring us the cash.
Okay, I would have to sign it and then cash it, and then, like I said, I spoke
All right.
with.
So here's what I'm gonna do. I find you in contempt for your failure to make any payment, not one, since last November 7th of 2024. I find you in contempt additionally because you failed to even update the court on what's going on until you wanted something from the court. Based upon your failure to make any payments and your failure to update the court and to figure something out, I don't find that you were unable to make any or have any ability to work at all because it's $25. The court, at the last time that you tried to modify the agreement reached with the court, agreed to $25 a month payment. And it's been since March, April, May, June, July, August, September, October, November. So that's 8 months that you failed to make any payment on the payment that you renegotiated. So I do find you in contempt. So what I am going to do is I am sentencing you to a period of 45 days in the county jail. And I'm ordering that your purge would be to pay $250 cash, which would be your check. The soonest you get it, the soonest you're able to get that cash and pay, you can purge, and you can, the court will then stay on the remaining amount of days that you have been sentenced to. And then the monthly payments from there will be $50 a month thereafter. And so that means $50 a month to begin and to start as of January 1st, 2025. Okay, January 1st, 2025. Oh, 26, sorry. We're already in 2026. So January 1st, 2026. So the soonest you're able to come up with $250, you get your check, you get it cashed, you get it here through whatever third party you wish to do, you can be released, and I'll set aside the remaining days that you have, and I'll kind of put that on hold. Okay. All right, Ms. Thomas Schmidt. And the reason why the court is doing this, I'm sure you understand, I'm sure you have a very full understanding of why, not only because of what was reached and entered into as of November 7th, 2024, but the fact that this is a conviction from 2015 and there has been very little, if any, payments made, and the victim has not been made whole, not even any attempt to make the victim whole, or to attempt to any means to attempt anything in this matter. Ms. Thomas Schmidt.
Your Honor, I'm going to request that the child support portion be reset to January 29th. Let's see, what time was this on for? At 10 a.m. or 11 a.m.? 10 a.m. And I would remind Mr. Merrill, he's under an order to pay $143 per month towards his support and $25 per month in arrears. I particularly remind him of this, given we have information that the tribe is paying per capita in the month of December in the amount between $700 and $800.
Ooh, that's even more that could go towards restitution too. But children are kind of two victims here. That's the hard part. Two victims, but I have little ones. How much is owed in arrears?
$16,954 is arrears, and then there's additional interest and then fees. So the interest is $4,645. So we're talking $21,000.
Wait.
I am not a member of the St. Croix tribe. I'm from the Red Lake Nation.
Oh, okay. So I apologize. I don't have information as to anything in December for that tribe. I apologize. I misunderstood.
Okay, you're the Red Lake Nation?
Yes, that's where my
All right.
$250 will be coming from.
Okay. All right, so the court will reset child support to January 29th at 10. The court's contempt order stands. The soonest you get somebody to come and facilitate $250, you can be released, and I'll set aside the remaining amount of days to sit, okay?
Yes.
We are adjourned.
Let me see if I understand this correctly. I got to make sure I understand this. So that gentleman owes $21,000 in back child support. He's forced to pay $143 a month in his regular child support, which is like what? $4.80 a day child support, right? Like something like that. And then $25 per month for his arrears. He will never pay that child support back. What is with the deadbeat dads out there? Oh my, pay your damn child support. Yes, there's deadbeat moms too. I know that. So, save your comments because I know there are mothers that don't pay either, but wow. Oh my goodness. $143 a month for child. That doesn't pay for. Okay. All right. That's another rant for another day. Maybe I'll go on with Dan on the pre-show and we'll talk about this. Yuck. All right. Anyway, let's really lighten it up and go to Louisiana. If that's lightening it up. Based on how things have gone in Louisiana this week, I think this could be very, very interesting. I have no idea what this is going to be, though. So let's find out. Let's go to Louisiana. It's the Louisiana Board of Pardons and Paroles. Good morning.
We are reconvening now at the Ascension Parish Jail, and we have Mr. Butler in front of us. Mr. Butler, morning.
Can y'all hear?
Yes.
Yes.
Mr. Butler, can you hear?
Yes, ma'am, I can.
Good. Would you introduce yourself? Tell us your name and DOC number.
My name is Demand Butler, DOC 491750.
All right, thank you. And you have counsel this morning. Would you introduce yourself for the record?
Yes, ma'am. Good morning. Kristen Trigg on behalf of Mr. Butler.
And you're appointed, is that correct?
That's correct.
Okay, thank you. So, Mr. Butler, I will read the allegations against you because you're accused of violating the conditions of your parole. I'll read it out to you, and you'll enter a plea of guilty or not guilty. We'll have a conversation with it, and then also with your attorney.
And before we start, I had spoken with my client prior to today, and he advised that he was going to be self-revoking when I spoke with him last week.
All right. Well, Mr. Butler, is that still your wish, is to revoke yourself?
Well, since we're here, man, we just might as well go on with the board up. The charges that they said that I'm currently in jail for, it's been mistaken, ma'am. I didn't commit those charges. For as it comes to.
Do you want to proceed or not? Do you want to revoke yourself or do you want to proceed?
Proceed.
So, Ms. Trigg, we'll go ahead and proceed. Thank you.
Okay, thank you.
So you're accused of violating condition number 4. Again, after I read it, I'm going to ask you to plead guilty or not guilty, and then you can talk about it. Condition number 4, there's 2 instances. One is you violated this condition by committing the offenses of second-degree battery and resisting an officer, 2 counts. You were arrested February 29, 2025 by Ascension Parish Sheriff's Office and charged with those offenses. On June 24th, 2025, the Ascension Parish District Attorney now crossed the second-degree battery. You pled guilty to resisting an officer on that same day. So how do you plead to violating condition number 4 in that instance?
What is condition 4? Resisting or whatever it is?
Criminal activity.
Ma'am?
Condition number 4 is that you will not be involved in any criminal activity. So it's alleged that you were involved in criminal activity as evidenced by your arrest and your plea to resisting an officer. So how do you plead guilty or not guilty to violating condition number 4?
Guilty.
Then there's another instance of condition number 4. And remember, that's about criminal activity. It says you committed the offense of battery of an officer on October 25th, 2024. You pled guilty to battery of an officer, 2 counts on December 16, 2024 in St. James Parish. How do you plead to that instance of violating condition number 4?
Guilty.
Lastly, has to do with your payments, and that's condition number 10. It says you failed to make any payments towards supervision fees since you've been on parole supervision. So how do you plead to violating condition number 10?
Not guilty.
Not guilty? Okay. So let me ask you this. You pled guilty to both instances of condition number 4. Tell me why you feel like you're not guilty of condition number 10, which has to do with your fees.
Currently, I was out of work and I'm disability. I'm waiting still on my disability, so that's been postponed.
So you weren't able to pay your fees because you didn't have the money. Okay. And let me ask Ms. Trigg, is there anything you'd like to add to this conversation?
No, just other than what Mr. Butler said, that he didn't have the money due to him waiting on his disability to pay the fees.
Mr. Butler, is there anything else you'd like us to know?
Not really.
Okay. Well, listen, based on the fact that you pled guilty to condition number 4 twice today, my vote, I find you guilty of violating condition number 4. And my vote today is to revoke your supervision. Mr. Freeman
I concur for the same reason.
and Mr. Byron.
I concur for the same reason.
All right, Mr. Butler, good luck to you, sir. But today we're revoking your supervision. Good luck, sir.
He could have saved us a few minutes and just revoked himself. I mean, that would have made things a lot easier for us. Oh, well. There you go. That's the Louisiana Board of Pardons and Paroles. Let's head over to Texas. Judge Boyd. Oh, that's my bad.
Hello.
Enjoy one of your true happy belated birthday.
Oh, thank you. Oh, it's not belated because I celebrate the entire month, so you're on time. All right, the court is calling 2025 CR 007217 State versus Desmond DeBrian Gomez. Can I have parties announce?
For the state.
Ron Korea for the accused.
And are you Desmond DeBrian Gomez? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
Yes, sir.
Are you the same Desmond DeBrian Gomez who's placed on deferred adjudication and cause number 2025 CR 007217 for the offense of harassment of a public servant on September 16, 2025 for a period of 5 years?
Yes, Judge.
All right, state.
Violated condition number 1 on or about the second day of October 2025 in Atascosa, Texas. The defendant Desmond DeBrian Gomez committed the offense of resisting arrest, search, transportation violations condition number 1.
How do you plead to that? True or not true?
True.
And then violated condition number 6 on or about the second day of October 2025 in Bexar County, Texas. The defendant Desmond DeBrian Gomez departed Bexar County without the written permission of the court and or the supervision officer in violation of condition number 2. Or 6. I'm so sorry.
6. That's okay. To that, how do you plead? True or not true?
True.
State will waive the remaining violated condition.
Any objection?
No objection her role.
All right. Did you understand by pleading true to violations 1 and 6, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison?
Yes, Your Honor.
Just one moment.
did not lose audio. Judge Boyd is just giving us
All right, on
a
this
pot
case,
there.
could I see the indictment, please?
One second.
Because there's a plea, we can go off the record, because there was a plea agreement on counts 1, 2, and 3.
Count 1 and 3 was on one, and there was a second for count 2.
Right, so I need to see that because.
The indictment did?
Mm-hmm. And I need to, no, I only have the stipulations because one of the counts is a state jail felony, the other count, 2 counts are 3rd-degree felonies. So I need these, I only have the stipulations for the state jail felony, not for the other one. And now we'll go back on the record. So that was counts 1 and count 2 were the harassment of the public servant. There's also a motion to enter adjudication of guilt on count 3 which was attempting to take a weapon from an officer. Is that correct, State?
See that counts 1 and count 1 is a harassment of a public servant, count 2 is attempt to take the weapon, and count 3 is the harassment. So 1 and 3 are the 3rd degree, and then state jail is count 2.
All right. So did you also review the document motion to enter adjudication of guilt and revoke community supervision as it relates to the count 2 attempting to take a weapon from an officer?
Yes, Judge.
All right, State, and if you could read the allegations for that count as well.
Violated condition number 1, on or about the 2nd day of October 2025 in Atascosa, Texas, the defendant Desmond DeBrian Gomez committed the offense of resist arrest, search, transportation, and violation. Number 1.
How do you plead to that? True or not true?
True.
And then violated condition number 6, on or about the 2nd day of October 2025 in Bear County, Texas, the defendant Desmond DeBrian Gomez departed Bear County without the condition of the court and or the supervision officer in violation of condition number 6.
And how do you plead to that?
True.
State will waive the remaining violation.
Okay.
All right. Did you understand by pleading true to violations 1 and 6 and each of the counts 1, 2, and 3, that in counts 1 and 3, the court could find it true, grant the motion, and sentence you up to 10 years in the prison? Knowing that, do you still wish to plead true to 1 and 6 and counts 1 and 3?
Yes, yes.
Did you understand by pleading true to violations 1 and 6 as it relates to count 2? If the court were to find it true, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fines?
Yes, Judge.
Knowing that, do you still wish to plead true to counts 1 and 6 and count 2?
Yes, Judge.
All right. Then in counts 1, counts 2, counts 3, the court will find violations of 1 and 6 true. Is there a proposed agreement?
There is not, Judge, to my understanding, state would be recommending on counts 1 and 3 for entering adjudication of guilt, revoking community supervision, and sentencing to 4 years in prison. And then on count 2, enter an adjudication of guilt, grant state's motion to revoke supervision and sentence to 2 years, running of the cases.
And defense, what are you requesting?
We're asking that he be put in SATA or continued on probation, zero tolerance. Give my reasons why if you'd like to hear them.
Yes.
You want to raise your right hand?
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Judge.
All right, you can lower your hand, state your name for the record.
Desmond DeBrian Gomez.
All right.
On the date of your arrest for harassing a public servant, were you on drugs or were you?
Okay, I'm sorry, counsel. You're gonna have to speak up. I can't hear and I know the court reporter cannot.
Were you using drugs on the time of the date of the offense?
Yes.
Do you have a recollection of how you harassed a police officer?
Not the best recollection, but somewhat.
Okay, and when they alleged that you try to take this down, we also want. Under, they didn't fill with drugs or alcohol,
Yes,
drugs, I mean,
yes, drugs.
okay, now, they allege that you left Bear County. While you were put on probation, but before that, they also said that you failed to report. Can you tell me if you ever reported to the probation officer, county's office after you were released on probation?
Yes, I reported to the office, in front of the jail. And I was supposed to have a meeting with my, probation officer on the 22nd. I went in there and I, talked to the front desk. They called my probation officer and got my picture taken in there. And then, from there, I left.
Did they ever make any attempts to make another appointment with you?
No, I had an appointment on October 22nd.
Okay, and when you were released on probation, initially, I believe did you have a conversation with the judge of where you wanted the probation to be at?
No, not initially, but, it was brought to the judge's attention that I was from Beeville. And that I wasn't from Bear County, but I did state that I did have an address here to live at whenever I was released.
And can you tell me something about the address that you were supposed to be living in San Antonio?
When I showed up, everybody there was a lot of drugs there, and it was too much for me when I got there. I got out and I just tried to stay with my head straight. And I went to Haven for Hope, and 3 days from there, that's whenever I just decided that I wanted to go to Beeville to be with my family and see my kids.
And do you have a place to live over there?
Yes,
Okay, how old are you?
23 years old.
When you turn 24?
July. This coming July.
Oh, next year?
Yes, sir.
Okay, and you said you have kids, how many kids you got?
I have two,
How old?
3 and 6.
3 and 6. Yeah. Now, you were arrested for possession of a dangerous drug in county, was it? Atascosa County. What was the dangerous drug that you had on?
Xanax.
And you have a prescription for Xanax?
Yes,
And how long have you had a prescription for Xanax?
for the last 5 years.
Okay. And that's the drug that they didn't find any other drugs?
No.
Okay. And so you reported you couldn't live in the house here. So you went home. You never missed did you miss that October 22nd?
I tried to, well, I didn't pay my bond in Atascosa. I tried to get to my probation officer before then. My family was gonna bring me from Beeville to San Antonio. Come report.
Were you in jail when you were supposed to report?
Yes,
Okay, so you were unable to report because you were in jail.
yes,
And that was on October 22nd?
yes. I paid my bond. I tried to go report, but I was, at a warrant free.
When were you released?
I wasn't released. I was extradited from Atascosa to Bear County.
Okay. All right, and I guess, what are you asking for the judge to do with your case? Are you asking her to continue you on probation? Or what exactly do you want her to do?
I'm asking for leniency to continue my probation and please try to get me moved to the county where I have somewhere to live and where my kids are and where I have a job. Because here in Bear County, I'm not from here and I really don't have nothing here. Nothing at all. I know nobody here, no family here.
And you have a job?
I did have an aunt and a cousin here that I was gonna stay with, but they were all on drugs. Showed up. That was all I had.
Right, and you're saying, I mean, other than the Xanax, do you have problems with other drugs?
Yeah, I have in the past. I've been incarcerated for the last almost 8 months. Before being released on probation, and I've been sober off anything since then.
Do you think Sadex would be helpful?
Yes, I think it would.
What is that?
Well, I think it would. I think it wouldn't at the same time. I know what choices I need to make. It's just I don't know why something gets in the way of me behaving. I guess it's just with myself. There's no other excuse.
Now, in Beeville, do you have a support system?
Yes,
And who would that be?
my mother, my father, my grandmother, my aunt, my children,
Okay, and where would you live?
with my grandmother.
Your grandmother?
Yes.
And does she have any rules?
I mean, yeah, of course, everybody do, basic rules. And before they don't, I mean, you can't be coming in and out late. Stay clean. And work.
Work? And where would you be working?
Be working for my uncle as a surveyor and, doing concrete work.
Oh, you do concrete?
Yes, sir.
And so you're asking the judge to continue on probation if she deems it necessary to give you some kind of drug help, you think that would be appropriate?
Yes.
Okay. All right, no further questions.
Any questions?
Yes, so very briefly, Mr. Gomez, you stated that, when you got out of jail, you attempted to contact your probation officer, is that correct?
Yes.
How did you attempt to make that contact?
I went to the probation office across the street and, the front desk receptionist, got in contact with the probation officer, set me an appointment and then took my picture and, then that's when I left the office.
And that subsequent appointment, did you make that appointment?
Yes,
And so it was a successful meeting after that?
yes,
Okay. And, at any time did you tell your probation officer you were leaving the county?
no,
Why not?
I didn't have a phone. I tried to go to the jail and call her from the jail phone, but they wouldn't let me use it. I didn't have her number. I just knew her name and the address where I was gonna meet her at. I did have the paperwork though, but I'd lost all my paperwork because it was in a backpack. Someone stole it.
But you stated you have a support system out of county, correct?
Yes,
Do those family members have phones?
yes,
Are you capable of using the internet?
yes.
Could you have Googled Dare County Adult Probation to find a general phone number?
Well, I wasn't with any of my family. I was just on my own out here when I got released from the jail. I was just walking in the streets.
Okay, so would you agree with me that it would be a little difficult for this court to believe that you'd be able to follow the rules of your community support, your family members' rules for their homes, when you couldn't even comply with the conditions of probation in this case?
Yes.
Yeah, no further questions, right?
Any further questions?
Well, would you be able to comply with all the rules of probation, all the conditions? If you have that support system and you're living in Beeville?
Yeah.
And you would be fully employed?
Yes, fully employed.
Okay, and that's where your kids are, your grandmother, your parents, and do you have any other brothers, sisters, or anybody else?
Yeah, I have two sisters.
And are they helpful for you? With you?
Yes.
Okay. No further
They're younger, but they're helpful.
Okay. No further questions, Judge.
All right, I have a few questions if there are no objections.
Okay.
All right, so when you left Bear County, you went to go live with family?
Yeah,
And who did you live with?
my grandma,
All right, and who else was living there?
my aunt, my uncle. So,
All right, and were your children living there?
no.
Were you living with your children at any time?
No, they live with their mother, but I did have, I met up with her and I got to see my kids when I first got released.
Okay, so what I don't understand is why you can get to Beeville, what is the distance from here to Beeville?
About 80 miles.
So how did you get to Beeville?
This guy that I had met at the gas station, he told me he was heading towards Corpus, and he told me he would drop me off in Eville.
All right, so this guy you met, complete stranger,
Yes, ma'am.
and they gave you a ride? Yes or no?
Yes.
And they wouldn't let you use their phone?
Well, I didn't really ask. I didn't.
All right,
I was just going to.
so, and when did this happen? When did you get to Beeville?
I never really got to get there. I got pulled over in Atascosa.
All right, and so you were able to do all of this, but not pick up the phone and call probation? And you left Bear County without getting a approval from the court? Okay. All right, this is what the court is going to do. I don't think you're a good candidate for probation. The court, as previously stated, is finding 1 and 6 true in counts 1, 2, and 3. Counts 1, 2, and 3 will run concurrently. The court is going to revoke. The court will find you guilty. In count 1, the court will sentence you to 5 years in the prison. In count 2, the court will sentence you to 2 years in the prison. In count 3, the court will sentence you to 5 years in the prison. There's to be no residing in household with minors. There's restitution to Juan Veritis, Vertiz, James Trotty, Trottie. There's to be no unsupervised contact with minors. Court will give you credit for any time served, and the court will request the therapeutic community. Therapeutic community does not increase the time that you're in custody. It's to help you with any type of drug or alcohol issues you may have. This is not a plea bargain agreement. Did you review the trial court certification of defendant's rights to appeal with your attorney?
Yes.
You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over that, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. You have children. You got to change your life. Otherwise, don't go bringing chaos into their lives. You understand?
Yes, Your Honor.
All right, good luck to you. You're welcome.
Have a seat, sir.
All
Can I
right.
see the parties, Giovinco? All right, we're back on the record in 2025 CR 004128, State versus Simon Alexander Garza. I have parties re-announced for the record, please.
Marissa Giovinco for Mr. Garza.
And you're Mr. Garza?
Yeah, that's right.
All right, we have by Zoom, Officer Pryor. Officer Pryor, could you unmute for me, please? Deputy Laura, is the sound on?
We'll hang with Judge Boyd for a little while longer. We're just doing a little overtime here, and figure we'd see how this turns out, and then we'll call it a day.
If you could speak up a little bit.
Good morning, Your Honor.
Good morning. All right, so I'm calling you on the case of Simon Alexander Garza. Do you have that pulled up?
Yes, ma'am. Yes, ma'am.
So could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Alicia Pryor.
All right, so this is going to be slightly different from a question and answer situation. I wanted you to zoom in because there's been testimony about his being allowed to work after hours. And so I'm trying to figure out if there's an issue because sometimes he has to work overtime. And his attorney has stated, and he stated that there is a 30-minute window for him to return home after work, but that sometimes he has to leave early because he won't make that window. So I just wanted my orders to be clear, and if there's some confusion, we could clear it up. So I'm ordering that he's allowed to work. He's on partial GPS. So is there anything that I would need to put in my order? For example, he leaves work at 3 o'clock or 5 o'clock. Sometimes you run into traffic. We have construction all over. Is there going to be an issue, or do I need to put something in the order where you all can just track him and you can see that he didn't make any stops? He's coming straight from work to home, but maybe there's construction, maybe there's traffic, and he's not going to get back home, within the 30 minutes allotment. Is that going to be an issue, or is there something I need to order?
No, ma'am. We give an hour for travel, or he has an hour of travel time. So he's able to get home. He needs to be home by 4:30 p.m. is what I currently have, since he's scheduled to leave work at 3:30.
All right, so they're giving you an hour. Is an hour not enough time for you?
Not the one day that I did try to
I'm sorry, you're gonna have to speak up so she can hear.
so the day that I did try to leave work at 3:30 exactly, I ended up getting home at around 4:20, which is 10 minutes away from that cutoff time, and I didn't want to risk any accidents maybe happening or construction or something.
All right, so this is what I can tell you. Normally what ends up happening with with violations on pretrial matters, one, it comes to me. Two, I'm sure, Ms. Pryor, if you see that he's not home at his allotted time, you're able to look and see that he's traveling on his way home and maybe there's some issue with traffic. I could be wrong, but I don't think they'll be filing a motion for me to review to as a violation report if you're 10 minutes late. They will usually, and correct me if I'm wrong, if you're late, they will look at the tracking and they will see. And then it will come to me and say, oh, this person stopped at HEB, this person stopped at a club, but that's when I'll get it. You understand?
Yeah.
Is that correct, Ms. Officer Pryor?
Yes, Your Honor. So we'll call the defendant to see why he was late, if it was due to traffic or if there is an issue with the car or whatever may have happened. If there was an unauthorized stop, then we would do a violation.
So they will call you. So just be available for a phone call. So there's not a problem with you working overtime. You just need to let them know that you're working overtime. And if, from what I'm understanding from the witness, is that if you're scheduled to leave at 3:30, but there's overtime work, all you have to do is email or call them and say, I'm still at work, I've gotten overtime, and then they will track you.
May I ask her a question, Judge?
Sure.
Okay, Ms. Pryor, as far as if he were to get a last minute, same day overtime shift, is he able to do that or is he supposed to be giving you advance notice?
It is supposed to be advance notice, just because I'm personally in the office from the hours of 8 to 5, so I could put his schedule in. The on-call officers wouldn't be aware because they don't have access to my email that he's requesting more time to be at work. So if he's scheduled at that time for 3:30 p.m., he has to be home by 4:30. He wouldn't be able to do that day of overtime.
Okay. So here's my question. Do you work on weekends?
I currently don't.
All right. So what you do is you send an email to them. And the person who will be submitting the violation report would be you, or would it be the person who's working at the desk?
For me?
Yes.
Sorry. For the violation, can you ask the question again?
All right.
Sorry.
So if for some reason, because you say you're scheduled from 9 to 5, if he works over, would you be, and you're not there, and your email, nobody is able to check your email, would you be the person who would enter the violation report, or would it be the person who's on duty?
No, I would do the violation on return of business day.
All right, so you just send her an email and let you know you're at work. According to GPS, she'll be able to look to see if you were actually at your location or not. But if it's going to be overtime, this is the court's order, because I want people to work. If it's going to be overtime, you need to send them an email saying, I'm still at work, I'm going to be here overtime. She's just told you she would be the person who would enter the violation report, not the person on duty. And I'm making an assumption here, and if the assumption is incorrect, let me know. My understanding is that even if it was somebody who was not your normal officer, they would still call you and say, hey, where are you at? That was a bad sentence. I mean, my English professor would be horrible and upset with me for ending with a preposition. So they will call you and say, where's your location? Why are you not at your designated location? Miss Dixon, I apologize. You taught me better. And so did my mom. So you just need to make sure that you're in contact with them. And if you have an extra shift, just send them an email. You understand? Are you able to do that? All right. So, and just be available for phone calls. So if something happens and you're supposed to be home at 4:30 or whatever it is, she's already stated that they will call you and say why you're not at home. And you can tell them, you can look, I'm stuck in traffic. All right.
And Judge, can I still be heard on argument? Because that's not our only issue.
No, you can still be heard on argument, but is there anything else from Officer Pryor?
No, Judge.
State anything from Officer Pryor?
No, he's been really compliant, Judge. I don't
right.
have anything else to say.
All right, thank you so much. And thank you for zooming in on such short notice. I appreciate it.
Thank you, Ms. Pryor.
Yes, ma'am. You have a good day.
You too.
Bye-bye.
Yes.
Thank you, Judge. Judge, my argument is that Mr. Garza is a young child. He's a young kid. He's 22. He is not someone who has a criminal history. He is committed basically what they're saying is a traffic accident. This isn't someone who killed someone, even in a manslaughter, it wasn't an intentionally, knowingly, any form or fashion. This was a traffic accident allegation. And there's no disputing that with the state.
Okay, so with regards to that, I don't know if there's a dispute about that or not. I don't have any facts.
Well, Judge, I think the legal definition of a manslaughter is a reckless killing, so that's what he's indicted for. Sure.
So that's all I know is what's in the indictment. I don't know any facts. If people want to call witnesses and place them under cross-examination for the facts of the case, then that can be done.
Yeah, and Judge Mr. Garza did testify that this was a traffic accident.
Do you want him to be cross-examined over the facts of the case?
No, I mean, no, Judge, we've already passed and that was already done. But he did testify it was a traffic accident. I have not heard anything to dispute that. However, the purpose of GPS is to stop people from hurting other people, to stop people from committing additional crimes, to protect victims. The protection from the community, we want to argue for the state side, is driving. They're concerned about Mr. Garza driving. He testified he is not driving. There is a condition of bond that he not drive. The GPS does not add any additional protections that it is intended for. This is not a case for GPS. He has also been on GPS since July of 2025 with 0 violations, and it is creating a safety hazard for him at work. I believe we've solved the hour issues, and I appreciate that, Judge, but it is additionally causing a safety issue for him at work, and it is unduly burdensome and not necessary in this case.
State?
Good. We believe it's necessary in testimony that in the 2 years that he was not indicted, we put up a speeding ticket. And so I think from the state side, it is necessary to monitor him for the safety of the community. And so we'd ask that we keep it out of order.
All right, thank you. All right, the motion will be denied.
Thank you, Judge.
Thank you. Anyone else ready?
Yes, Judge, we have.
All right. Well, that seems like a very logical place to kind of wrap up this episode of TCF Live on a Thursday. Really do appreciate you guys joining me today. We went into a little bit of overtime, but we've gone into overtime pretty much every day that I have been here because that's just how I like to roll. I like to make sure you guys are getting your money's worth. That being said, thank you to Grandma TCF for the super sticker today, or the super chat. Thank you to Barbara for the super and for the gifted membership. Thank you, everybody who's been so supportive these last couple of weeks. Really do appreciate it. We have one more day. So as I said previously, if you really like me filling in, well, the bad news is there's only one more day. If you're excited to get Dan back, the good news is you got one more day. And tomorrow is a Friday, so of course, you know, we've got lots of excitement planned out for Friday. We'll probably do another round of overtime. Who knows? Maybe some dungeon court tomorrow as well. It's always fun on a Friday, a super duper Friday. That's what we're hoping for. All right. Real quick, before we wrap it up, 8 p.m. East, 5 p.m. Pacific tonight. Join me, will you, for Sidebar. It'll be myself, Ashley, Bailey, and Lindsay. Will be talking about witnesses. Yeah, witnesses. We saw in the Louisiana Board of Pardons and Paroles earlier this week that sometimes a witness can be a worst enemy. In this case, really, for the state. So that's always an interesting aspect to these cases are witnesses and how valuable their testimony can be, how they can help you, how they can hurt you, and so much more. There's lots of angles. I'm sure Bailey will have a very unique perspective and take us in a direction that we did not expect to go, because that's his role. My role will be as host, and Lindsay and Ashley, well, they will try to keep me in line and probably to the best of their ability. Well, we'll see. And then, of course, the one and only Michelle will be executive producing tonight, as she has here today. Thank you so much. I want to thank you all once again for hanging out, bearing with me through any sort of technical issues, and the dog and all that downstairs. That was a little bit of a mess this morning, but we made it through it. All right, we'll see you tomorrow, 10 a.m. East, 7 a.m. Pacific, 45 minutes early for channel members, because Dan will have the pre-show, provided he has the internet that is capable of giving you a pre-show tomorrow. If not, then join me tomorrow morning. All right. See you on Sidebar tonight. Good night, everybody.